And we are live.
Good morning. Welcome to the April 26, 2022 meeting of the Durham Board of Adjustment. My name is Jacob Rogers. I'm the chair of the board. I'd like to start by acknowledging that we are conducting this meeting using a remote electronic platform as permitted by Session Law 2020-3. The BOA, the Board of Adjustment, is a quasi-judicial body that is governed by the North Carolina General Statutes and the city's Unified Development Ordinance. The board typically conducts evidentiary hearings on requests for variances, special use permits, among other requests. Today's meeting will proceed much like an in-person meeting of the BOA. On the screen, you'll see members of the board. Additionally, planning staff and representatives from the city and county's attorney's offices are attending in the remote meeting. Applicants were required to register in advance and are also attending the remote meeting. When a case is called for its hearing, applicants and witnesses will be promoted within the remote platform so their video can be seen. The chair will swear in applicants and witnesses at the beginning of each case. Staff will present each case and applicants will then provide their evidence. Control of presentation and screen sharing will remain with planning staff. Today's meeting is being broadcast live on the city's YouTube site, and a link to this broadcast is on the website for the Board of Adjustment. Before we begin the evidentiary hearings on today's agenda, I would like to provide some important information about the steps taken to ensure that each party's due process rights are protected as we proceed in this platform. Each applicant on today's agenda was notified that this meeting will be conducted using this remote electronic platform. During registration, every applicant on today's agenda consented to the board conducting the evidentiary hearing using this platform. We will also confirm today at the start of each hearing that the participants in the hearing consent to the matter proceeding in this platform. If there's any objection to a matter proceeding in the platform, the case will be continued. Notice of today's meeting was provided by letters mailed to property owners and residents within 600 feet of subject properties, posting a sign at the property and posting on the city's website. The website and mailed notices for today's meeting contained information about how the public can access the remote meeting as it occurs. These notices also contained information about the registration requirement for the meeting, along with information about how to register. All individuals participating in today's evidentiary hearings were also required to submit a copy of any presentation, document, exhibit, or other materials that they wish to submit at the evidentiary hearing prior to today's meeting. All materials that the city received from the participants in today's cases, as well as a copy of city staff's presentations and documents, were posted to the BOA website as part of the agenda. No new documents will be submitted during today's meeting. No case is proceeding today in which the city has been contacted by an individual with an objection to the case or an objection to the matter it being heard in the platform. All decisions of this board are subject to appeal to the Durham Superior Court. Anyone in the audience other than the applicant who wishes to receive a copy of the formal order issued by this board on a particular case must submit a written request for a copy of the order. I'd like to now ask if anybody on the board would like to share if they've had any ex parte communication, or if need to recuse themselves from any of today's cases. Hey, Mike.
Morning, Chair Rogers. I'll be recusing myself from case number B220009.
All right. Mike Tarrant.
Good morning, Mr. Chair. I'll need to recuse myself from case B22000013.
Got it. All right. Let's do roll call real quick. Amanda, got everything fixed? No. Can anyone else hear Amanda? Okay.
I can do roll.
Yeah, I could do. Okay, go ahead, Jessica.
All right. Mr. Kipp, absent. Mr. Meadows.
Here.
Rogers.
Here.
Retchless.
Here.
Paletta.
Present.
Major. Absent. Tarrant.
Here.
No.
And Boucher.
Jessica Major is here.
Is she here? Jessica?
Yes.
There we go. Thank you. Sorry, I missed you.
All right. So for cases B220009 and B22000013, Chris, will you promote the applicants for those two cases?
Chair Rogers, would
Yeah.
you like to vote on
The
Ian
minute?
Kip's absence for whether it should be excused.
He didn't ask for one. Do we still do that?
He did ask in a later email.
Okay, to you. All right, would anybody like to make a motion that we excuse Ian Kip's absence from today's meeting?
I'll make a motion, Retchless.
All right, Mike Retros on that. Who wants the second?
I'll second Beauchesne.
Natalie Beauchesne on the second. Jessica, you or Amanda want to call that, or do you want me to?
Amanda, are you able to, or shall I go ahead? I will go ahead. All right, Meadows,
Yes.
Rogers,
Yes.
Retchless,
Yes.
Paletta,
Yes.
Major,
Yes.
Tarrant,
Yes.
Beauchesne. 1, 2,
Yes.
3, 4, 5, 6, 7. Motion carries 7-0.
All right, good deal. All right, just before we get into much more of the agenda, whoever, for the applicants on cases 9 and 13, we've got 2 folks who are recusing themselves, I guess 1 on each. That means we'll have 6 members of the board hearing those cases. You have the choice of continuing with 6, or we could continue the meeting to where you can have a full board. So I want to ask what you prefer.
Chairman Rogers, this is Patrick Biker. Can you hear me, sir?
I can.
We're fine proceeding with the board today, sir.
Okay. In your case,
Central Park.
okay. And the other,
He's here.
I'm not sure.
Sorry. Yeah, Central Park and East Gear. We're fine with both of them, sir.
Okay. All right, we'll continue. So next thing on the agenda, any adjustments to the agenda? Hearing none, seeing none. Let's
No.
move on. I'm sorry. Cole, you got something?
I was saying there's none. Yeah.
All right. Good. Approval of the minutes from the last meeting. I'm hoping that everyone's had the chance to review those. Is there a motion to approve?
Meadows, move approval.
Meadows on the first.
Retchless second.
Retchless second. And
It helps if you unmute. Ready to vote?
yes.
All right, we have Meadows,
Yes.
Rogers,
Yes.
Retchless,
Yes.
Paletta,
Yes.
Major,
Yes.
Tarrant,
Yes.
Beauchesne.
Yes.
Motion carries 7-0.
All righty. Well, we're going to move on to the first case.
All right,
Clarify seating and call the case.
it has been a minute. So our first case is B22-00007. It's a city case. A request for a variance from the outer 50 feet of the 100-foot riparian buffer and 10-foot no-build setback. The subject site is located at 2120 East Gear Street, is zoned Planned Development Residential 3.360 or PDR 3.360, and Residential Rural RR, the Falls Jordan Lake Protected Area Watershed Protection Overlay or FJB, Major Transportation Corridor I-85, MTC I-85, and in the suburban tier. The case has been advertised for the required period of time. Property owners within 600 feet have been notified, and notarized affidavits verifying the sign posting and letter mailing are on file. The seating will be Meadows, Rogers, Retchless, Paletta, Major, Tarrant, and Beauchesne. And Cole Reniger is the case planner.
All right. Thank you, Jessica. Would the applicant and anyone who plans on speaking presenting evidence on case B22-00007, please turn your video on and we'll administer the oath. And Chris?
Yes, I just have one individual, Earl Quick. I'm trying to promote them as a panelist at the moment. Earl, if you are getting notifications, please accept that. So you may be brought into this case.
Okay.
And it should be coming in any second now.
For the oath, we'll need your camera on so we can administer the oath. And I have one more question.
I see him coming on, so he should be any moment now.
Okay.
Good morning. Hello.
Hi there.
Hi. Yes, I'm Earl's wife. He wasn't able to attend. My name is Sharon Crawford Quick, and yes. What do you want me to go ahead and start or not?
I'd like for you to. So we have to minister the oath, and then we can get started. Are you the applicant? Is there any chance that you could turn your video on? There we go.
Hi. Good morning.
Morning. Is anyone else planning on speaking on this case? All right. All right. So if you'll please raise your right hand, everyone who plans on giving testimony in this case, do you swear or affirm the testimony you'll give today is the truth and nothing but the truth? Earl Quick, I mean, I know that's not your name. I cannot. It was cutting out. What's your name again?
Yes. Yes, I do.
Okay.
Sharon Crawford Quick.
All right. Dan?
Yes, I do.
Patrick? Biker?
Yes, sir, I do.
Leah?
Yes, I do.
All right. Thank you. And do you consent to this remote meeting platform? Biker?
Yes.
Leah?
Yes.
Dan?
Yes.
And Shannon or Sharon?
Sharon.
Share.
All right. So Sharon, did you say yes on the remote meeting consenting?
Yes.
Okay.
Yes, I do.
It was
I do.
breaking up on my end. Sorry about that. All right. Well, we'll turn it over to Cole for
I'm sorry.
present the case.
Okay. Make sure I'm going with the right one. Oh, sorry about that. Good morning. I'm Cole Reniger, representing the Planning Department. Planning staff requested the staff report and all materials submitted to the public hearing to be made part of the public record with any necessary corrections as noted.
Noted. Thank you.
Case B 20-0007 is a request from a variance from the outer 50 foot of the 100-foot riparian buffer and the 10-foot no build setback. The case area is highlighted in red. The site is in a suburban tier, zoned planned development residential and rural residential, and is in the city of Durham's jurisdiction. The existing use is vacant residential. Leah Bergman, applicant, requests a variance to encroach into the outer 50-foot and the 10-foot no build setback of the 100-foot riparian buffer required on the site. The 76 square foot of project area in the stream buffer and 297 square feet of the no build area will be for a corner of one of the proposed multifamily residential buildings. The subject site is on planned development residential and rural residential. The subject site has a rezoning request to residential suburban multifamily pending. It is in the Falls News Jordan Lake protected area. Falls of the Lake Jordan Lake protected area watershed protection overlay and an MTC I-85 corridor overlay. Per Development Unified Ordinance Section 8.5.4 C.1 for intermittent and perennial streams. Measurement of the riparian buffer begins at the top of the bank and extends landward, and the required distance on all sides of the surface water measured horizontally on a line perpendicular to a vertical line marking the top of the bank. For the subject property located in the suburban tier and in the FJB watershed overlay, there is a 100-foot buffer and a 10-foot no build setback. When impervious surface limits exceed 24%, the inner 50-foot is a state mandated riparian buffer, but the outer 50 is an additional city mandated requirement. The applicant only plans to encroach into the outer 50 and 10-foot no build setback. Sorry, and there's the plan, and that red section is where they plan on encroaching. I see that Chad has a question.
Mr. Meadows.
Thank you, Mr. Chair. Good morning, Cole.
Morning.
I just wanted to be sure that I understood what you said. There is a pending rezoning that applies to this piece of property Did I hear that correctly?
Yes, that's correct.
And so I'm assuming that decision has not yet been made. Is that right?
That's correct.
Would this use be allowed on this property if that rezoning is not approved?
I do not believe it would have to be a different design. They can still do multifamily residential, but the density would have to change because of the PDR density. I think is at 3. So it could still be used for multifamily, but not necessarily this use.
Would the density that was allowable under the PDR 3, would that be less than what's being less than what's depicted in this application?
I believe so.
Thank you.
So this is Jessica Dockery's planning staff. So that being said, would you please keep that in mind when you craft any motion at the end so that you are including the caveat that this be approved zoning before your approval would take effect? We don't want to confuse that the Board of Adjustment has approved something that has to go through another process.
Understood.
Thank you.
All right. Any other questions for Cole before we hear from the applicant? Hearing none, seeing none. Would the applicant come forward, Leah or Patrick?
Yes, good morning, Chairman Rogers, Patrick Bonker. Can y'all hear me again? Just checking.
Gotcha.
Wonderful. Good morning, Chairman Rogers, members of the board. My name is Patrick Bonker with Morningstar Law Group. Our office address is 700 West Main Street, 2nd floor, here in Durham. I'm here today representing East Gear Ventures, which is one of Durham's fine affordable housing developers. With me today to present our evidence on this variance case is Mr. Dan Jewell, who is the president of CJTPA. I would also like to state for the record that Leah Bergman, one of the managers of East Gear Ventures, is here with us with Mr. Jewell and myself, and also Tammy Stern is one of our land planners. She's definitely a rising star in the Triangle's affordable housing community. She's also on this call. At this time, Chairman Rogers, we'd like to have my resume and the resume for Dan Jewell, who's our site landscape architect with CJTPA, admitted into evidence as exhibits A and B to be a part of the record for this proceeding. These exhibits were submitted to Cole well in advance of this hearing. Also, Mr. Chairman, we also submitted exhibits C and D. Those are just colorized excerpts from the staff report. You're seeing a rendering of it on the screen right now. Exhibits C and D are simply there to help illustrate Mr. Jewell and my testimony to help illustrate the need for this variance. Does that mean with your approval, Mr. Chairman?
Yes.
Thank you. Very briefly, Mr. Chairman, members of the board, my experience, I don't mean to bore you with repetition, but I've been working in Durham for 27 or 28 years. I have a law degree and a master's in city and regional planning from the University of North Carolina, graduating in 1994. I'm also a lead accredited professional with the Leadership for Environmental and Energy Design, and have a fair amount of experience, I think the board would agree, in these types of regulations and zoning issues. And so just to give you background on my personal role in this, in preparing to testify this morning, I reviewed all the submitted materials, including the application, the site plan, the staff report and its attachments. I have visited the site personally. I'm very familiar with this section of Durham, having lived in Durham for almost 30 years. Just to give the board background, the site contains just under 7.2 acres located along East Gear Street, and it is just south of Farrell Road. At the outset, I want to stress for the board that this is an outstanding site for affordable housing. It is very close to necessary daily retail. There's a Walmart less than half a mile away. Glen Elementary School is also very close. I would say it's less than a mile away. Go Durham Route 3 provides direct transit service to this site. And then in addition to all those excellent aspects, the City Council recently approved a 220 industrial park along Farrell Road and Junction Road, and that will provide good paying jobs about a half mile away from the site we're looking at today. In other words, this location checks all the boxes for what we look for to build affordable housing that is desperately needed in Durham right now. To briefly address our order of presentation, I will address finding number 1. Then Mr. Jewell will provide competent material, substantial evidence on findings 2 and 3. And I'll wrap up our presentation by addressing finding number 4. After we address those 4 findings, I'll provide a brief summary that demonstrates we have met the required findings of UDO section 3.14 for approval of this variance. Let me go into number 1. East Gear Ventures seeks to construct a new 5-building multifamily development with affordable dwelling units at this location, which you can see in this rendering. If you look at more precise numbers regarding the stream buffer on this site, it's a 7.2 acre site, but out of that 7.2 acres, 2.65 acres are consumed by mandated stream buffers under the requirements of the UDO. That equates to 37% of the overall site. If you convert the acres to square feet on this site, there are 115,625 square feet of stream buffer. And we are asking for a building and sidewalk encroachments that amount to 373 square feet, which is 0.3% of those mandated stream buffers. Cole, would you be able to go to Exhibit D, please, to zoom in?
Sorry, give me a second.
Yeah, I think you got it. Thanks, Cole. As you can see, of that 373 square feet, 297 are in the 10-foot no-build setback, which Mr. Jewell and I affectionately refer to as the buffer. Only 76 square feet is in the outer 50 feet that's required by the Durham UDO above and beyond the 50-foot state mandated buffer, since we're in the Neuse River Basin. Besides that, and in the interest of full disclosure, we need a 5,667 square foot area for potential grading, but that will be revegetated and restored as required by the UDO, and that is 4.9% of the stream buffer on this site. And so for the following reasons, this variance is justified, and I will now address finding number 1. As you all know, finding number 1 is that unnecessary hardship would result from strict application of the ordinance. It is not necessary to demonstrate, in the absence of the variance, that no reasonable use can be made of the property. Unreasonable hardship would result from strict application of the ordinance because it would require East Gear Ventures to shrink its proposed development by at least 3 affordable dwelling units. I think it is fair to say Durham is experiencing an affordable housing crisis. And this is especially true for our least affluent residents. And they are the persons for whom East Gear Ventures will provide dignified and accessible housing. The parking lot configuration on this rendering we are looking at reflects the bare minimum needed for the people that it is East Gear's mission to serve. I want to stress the need for parking here because this is a requirement of the North Carolina Housing Finance Agency. I think as most members of the board are aware, almost every affordable housing project in Durham and across North Carolina has to be funded with a by the North Carolina Housing Finance Agency, which is the sole issuer of low-income housing tax credits. They have a host of regulations that are above and beyond the UDO. And so what we are looking at today in these renderings, Exhibit C and D, reflect what we need to do to meet the requirements of the North Carolina Housing Finance Agency, as well as the UDO. We need to recognize that this site lost a third of its area to stream buffer and the 10-foot no-build setback. This is a difficult site to utilize because of its triangular shape. That shape creates an unnecessary hardship because it limits the building and the parking area to the amount of square footage outside the stream buffer and the no-build setback. I also want to add that the spacing between the buildings that you're looking at here, that is the bare minimum as required by the fire code. And so we have to meet those fire code requirements. Accordingly, in order to be a good neighbor to existing residential that is adjacent to this site, we are trying to pull the buildings towards Gear Street and away from the existing neighborhoods. And so I do not think it is appropriate to shrink the project and say, well, just build a smaller building and build less affordable housing in order to remove the need for this variance request. And so that's our discussion on finding number 1. I'd like to now turn it over to Mr. Dan Jewell, our site designer, to provide testimony on findings 2 and 3.
Very good. Thank you, Patrick. Again, good morning, Chairman Rogers and members of the board. I'm Dan Jewell, president of CJTPA. We are civil engineers, landscape architects, land planners, and surveyors. I am a licensed landscape architect, have been since 1983. And after receiving my degree in 1981, I practiced in Texas for the first couple of years, but have been licensed and practicing in North Carolina, primarily in Durham, since 1985. So I'm now in my fourth decade of practicing here. We have done quite a few projects like this over the years. We were brought on to work on both the development plan for the rezoning of the site and work through the site analysis and things such as stream buffers, steep slopes, and that. Most importantly, to figure out this plan so that we can provide this important affordable housing development. In conjunction with the site plan, I worked on a variance application we submitted to the planning department on behalf of Ear Street Ventures. And in preparing for this public hearing, I've reviewed all the submitted materials, including the application, site plan, staff report, and the attachments that you've been looking at, particularly the ones that show the very small amount of impact of the stream buffer that we are requesting. I'd now like to address the second finding required in UDO section 314.8, that the hardship results from conditions that are peculiar to this property, and peculiar they are. First, and I realize this is repetitive from what Mr. Biker said, it is a peculiar condition to have these stream buffers that significantly impinge on both sides of this triangular shaped parcel, as the previous exhibit shows, that covers over 1/3 of the buildable area of this lot of record. Again, I would be hard pressed to find in my decades of experience a site with this double whammy of 2 stream buffers pinching on this triangular shaped parcel. And this is in fact a unique condition in my professional opinion. Now I'd like to move on to the third finding, which is that the hardship did not result from actions taken by the applicant or the property owner. Since East Gear Street Ventures acquired this property back in 1999, these UDO mandated stream buffers were adopted in 2006, well after the date of that acquisition. Therefore, none of the conditions on this property that are the subject of this variance request resulted from any actions taken by the applicant and our client. This concludes my testimony. I'll be happy to answer any questions at the end of our presentation or at the appropriate time. And I'd now like to turn it back to Mr. Biker to address finding number 4.
So Mr. Rogers, Chairman Rogers, members of the board, Patrick Biker again for the applicant. I will move on to the fourth finding, that the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. In regard to the intent and spirit of the ordinance, this variance is in accordance with section 1.2.2.u of the UDO that specifically encourages the development of affordable housing. If our team is successful with our application to the North Carolina Housing Finance Agency in order to obtain a 9% low-income housing tax credit, 1/4 of the affordable units at this site will be available for our neighbors who make less than 30% of the area median income. In order to meet the process requirements established by the North Carolina Housing Finance Agency, we have to have all of our discretionary entitlements in place just to submit that application. And so that's why we're before the board today, in order to obtain this variance, which we're running in parallel to the rezoning that the staff ably described earlier. And that will enable us to at least apply for a 9% low-income housing tax credit. That is the most effective tool available in North Carolina to provide housing for our least fortunate neighbors. Again, this site has great proximity to transit, shopping, an elementary school, and future job opportunities. Accordingly, I strongly believe that substantial justice is achieved by granting this variance, since it is a necessary step in the lengthy process that East Gear Ventures has undertaken to build affordable housing at this location. In the event we don't obtain a 9% tax credit, the 4% low-income housing tax credit at this point in time is the fallback option, which again would provide affordable housing at this location, which is desperately needed. And so for all these reasons, public safety is secured and substantial justice is achieved by granting this variance. And in conclusion, Mr. Chairman, members of the board, for all the reasons that Mr. Jewell and I have stated, I think the applicant has met the 4 required findings of UDO section 3.14. The board has received competent material substantial evidence in regards to the first finding, how unnecessary hardship results from the strict application of the ordinance, since the UDO requires more than 1/3 of this site to be unbuildable, and to reduce the size of this development would cost our community affordable housing for its most vulnerable residents. In addition, this is a very small 373 square foot encroachment into the outer 50-foot buffer and the 10-foot no build setback. Secondly, the hardship results from conditions peculiar to the property, solely due to conditions found within the 7.2 acres that the stream buffers and the new build setbacks impinge both sides of this triangular shaped piece of property and cover 37% of the site. Third, it is clear that on the record that the hardship did not result from any actions of Eastbury Ventures, which again is a strong Durham-based affordable housing development organization. And fourth, the requested variance is consistent with the spirit, purpose, and intent of the UDO for the reasons I just stated. Accordingly, I recommend that the board approve this variance. Thank you, Mr. Chairman, members of the board, for your time this morning. Mr. Jewell and I will be happy to answer any questions.
All right, thank you for that. Let's see, we've got some hands up. Chad was first. We'll go with you.
Good morning. Thank you, Mr. Chair. Good morning, gentlemen. Always a pleasure to hear from you. Very thorough presentation. A few questions for you. So how many units are proposed?
Right now it's 88, sir.
88. Is there anything that is, whether that's through the Housing Finance Agency or any other legal requirement that you need to have 88 units on this site?
Yeah, sure.
Certainly, sir. We're trying to create, as many affordable units and to get our cost per unit as efficient as possible and to provide as much affordable housing as possible. So yes, that's why we're seeking 88 units here. Could we do? Yes, sure. Sure we could, but we believe Durham actually needs many, many more.
Yeah, and the part of it is the economies of scale that come with this. The North Carolina Housing Finance Agency, I cannot overemphasize how hard they drill down on the project finances. And what they look at, Mr. Meadows, is the cost per unit. So every time you reduce by the number of units, guess what goes up? The cost per unit. So we lose economies of scale, and that jeopardizes our chance to obtain a 9% tax credit. And that is just the reality of it. We often talk about, does the deal pencil? That's sort of a quote unquote thing. And in my experience, and we can point to other projects, this is really the 88 unit count, a count in the high 80s is what the North Carolina Housing Finance Agency is looking for. They're looking for something north of 80 units in order to make sure those economies of scale are met. The most, shall we say, famous example was the Farrington Road Development Agreement project, where we had to have north of 80 units in order for that to qualify for financing from the North Carolina Housing Finance Agency. So it's really the nuts and bolts of turning in these applications to the Housing Finance Agency that drives the unit count, drives the parking, and that is the conflict we're dealing with today, sir.
Okay. Thank you. One more question. I'm sorry, go ahead.
One other point I'd like to make is, unfortunately, we are all dealing now with exponentially higher costs of building. And so, when we start, say, oh, can't you cut here or can't you cut there? Yes, but we are already dealing with very, very, significantly higher numbers than if we were building this project just a year ago. We're looking probably at 25 to 30% higher construction costs. In a market rate project, you can pass those costs on to the renters. In an affordable project, we are capped on our rents. And so again, as Patrick mentioned, the greater economies of scale we can get, the higher likely this project has of coming to fruition.
Thank you. I have one more question I wanted to follow up on, and that is the spacing between buildings 2 and 3. Mr. Biker, I think you indicated that you wanted to pull the buildings closer to Gear Street to be a good neighbor. The spacing between buildings 2 and 3 is the minimum necessary for the fire code.
Right.
I think is what you mentioned. Can you tell me a little bit more about why buildings 2 and 3 couldn't be moved, shifted to the, I guess, northwest, so that you can reduce or eliminate the encroachment into the riparian area?
Oh, no, the building at the top right corner is touching the stream buffer on the other side. So it's choose your buffer variance. You either choose the buffer variance that's closer to Gear Street or choose the buffer variance closer to the existing housing, our existing neighbors. We chose to go closer to Gear Street.
Okay.
So it's touched, the corner of the building is touching the buffer at the top, what would be the top corner of this triangle. So it's choose your poison. There is no way to slide the buildings. And if we put the buildings closer together, we wouldn't meet fire code standards. We wouldn't be able to put windows in.
Correct.
Thank you.
Yes, sir.
All right, next we
Appreciate it.
got Mike Tarrant.
Thank you, Mr. Chair. I had just really 3 clarification items, more so than questions. If I'm understanding this drawing correctly, this site cannot be accessed without impacting the stream buffers regardless, correct?
Right. It's a perpendicular crossing to come in off of Gear Street, which is our only public road access.
And those are by right, is that accurate?
Correct. The state law and the UDO both list that as an allowed use. The variance that we are requesting is not an allowed use. It's only allowed with issuance of a variance.
Great. And then regarding the actual impact itself, the area you've identified is really for, it appears to be just the building and the sidewalk, but doesn't account for building footings or grading, etc. So is there perhaps additional impact that should be considered here?
Yeah, Mr. Tarrant, if you look at Cole, would you mind switching back to Exhibit D?
Cole has stepped away.
Oh,
and
sorry.
I may not be able to do that for you. I apologize.
Okay. Well, if you can, Mr. Tarrant, if you can look at where the crosshatch area is, that's, I apologize, I had the exact number in my outline. It's approximately 5,000 square feet. That's a to allow for grading and construction. Yeah, here it is, sir.
Clearing and grading.
Yeah, 5,667 square feet as for potential grading, but all of that will be revegetated after the buildings are completed.
And that isn't allowed.
And that's allowed. That's allowed. We just want to be completely transparent with the board today.
I appreciate that, Mr. Bike. I apologize for the oversight on my part.
No, it's hard to read. It's always hard to, especially when we're remote like this. This is there's no doubt it's a challenge to understand everything that's going on.
This is Jessica Dockery from the Planning Department. I wanted to point out that the sidewalk itself is also considered part of the roadway. So that is why that is an allowable use, just to clarify.
Yeah, thank you.
Thank you, Jessica.
And the final clarification I had is the additional UDO buffer, if I understand correctly, is imposed because be applicable and you essentially have more area to develop. Is that correct?
I'm sorry, you broke up, sir.
I'm sorry, I just got the your internet connection is unstable. I apologize. The additional UDO buffer is due to the impervious surface being above 24%. Is that correct?
Yes, we will be above the 24%. Therefore, we will be having to use the high density option, which requires the bigger buffers.
Right, right. But I mean, it really, if you look at this, it really is. It's more of an infill project than not. I know East Gear Street has a certain feel to it, but I mean, keep in mind, there's a Walmart anchored shopping center a half mile due north. There's a very large industrial park a half mile to the east, and there's an elementary school that's 0.3 of a mile away. So it really, using the low density option was never really on the table for this particular site.
Understood. And Mr. Joy, I guess in your professional experience, what's the likelihood of being able to do walk-up style apartments with surface parking at a low density option?
Not feasible at all to do. This is the plan that works. This is the plan that works both from a tax credit standpoint and a financial standpoint. And if your question is if we were to reduce the density so it was less than 24%, the project would not be financially feasible nor financeable or tax credit worthy from the NCHFA.
That's all I have. I appreciate the clarification.
Great questions. Thank you.
Yep, appreciate it.
All right. Any other questions from board members to the applicant? Hearing none, seeing none. Is there anyone else here to speak in favor of this application or request for a variance? All right.
Hello.
Hi, Sharon.
Hi. Yes. Is it time for me to talk or not?
Are you here to speak in favor or in opposition?
Opposition.
All right. Yeah, I'm calling on you now. So if you want to, I'll turn it over to you.
Okay, thank you. Good morning. My name is Sharon Crawford Quick, and I am a resident at Landon Farms. And but basically, it is the area that they're talking about. We're not far behind there. I'm not for sure if it sounds to me like they're trying to put as many buildings as they can in a small area. And then not just that, no one knows until they live in an area. And me and my husband and my son, we've been living out there for about 15 or 16 years. We built our house and we know what it looks like when it rains. Right now, if it comes down a good downpour, those streams, those buffers they're talking about, a lot of water is emptied into those streams, those buffers. They are sometimes when you're going on gear in a certain area where they're talking about, there's like a big puddle there. And when you go through it, the water just splashes up on your car. So basically, I'm not for sure how that would go when if they do decide to go over some. It looks like to me erosion over years of rain, and then just thinking about just the water itself. Right now, KB Homes, they are building right next door to where they're talking about. And KB Homes, they did adhere to the buffer from what I can see. They had to build a drain area and it is full of water. And that's just a concern. That's one of the concerns that we have is the water and the flooding, because right now when it rains, sometimes the water builds up in our backyard and we're right behind where they're building KB Homes. So they're talking about putting as many buildings as they can in that small area. I think that I don't know if that would work because I'm looking at the water, when it rains. And that's just a concern that I have as a resident in that area.
All right. Thank you, Sharon.
Mr. Chairman,
yes.
I need to object I certainly do not object to Mrs. Quick's eyewitness testimony. However, under North Carolina General Statute 160D 1402, subpart J3, any testimony that requires expert testimony, certainly stormwater engineering falls into that category. Only a professional engineer can provide competent testimony on stormwater effects of a given project to this board. And so that objection is stated for the record, Mr. Chairman. Thank you.
That is correct. Mike, before we hear a rebuttal from the applicant, do you have a question for Ms. Quick? Mike Tarrant?
All right, no, Mr. Chair, Mr. Biker addressed that. Thank you.
Okay. Mr. Biker, would you like to?
Certainly, this project will meet all the stormwater standards that are very stringent in the city of Durham. Accordingly, our post condition post-construction conditions must be the same or better than the pre-construction conditions. So that's Durham has tough stormwater ordinances. Mr. Jewell and I have been on the record for many, many years supporting those ordinances, and the projects that we work on meet those ordinances, and this one will be no different. Accordingly, I think it's a necessary step that the staff very capably reviews and evaluates. We have excellent stormwater reviewers in the city of Durham. Accordingly, these conditions that we're discussing today, I think will be ameliorated as we go through the site plan process. And again, it's consistent with the other projects that Mr. Jewell and I have worked on for many years now.
All right. Let's bring this back to the table. Any discussion from board members? Or first I should ask, are there any other questions for the applicant before we get into deliberations and discussion? All right, let's bring it back to the table then. Thoughts? Mr. Meadows?
Good morning. Thank you, Mr. Chair. So this applicant and their agents are before us regularly. They know the ordinances very well. They understand state law very well. They always do a good job. They're very thorough, and I appreciate that. There are a couple of issues on this case that I need some help. Maybe you guys can help me work through. The first of those is, essentially what I understand the justification for the variance is cost per unit. More specifically, that without the additional 3 units that trigger the need for the variance, there is concern over the cost per unit impacting the project financing. So that's to me, that feels like a financial or a monetary concern that's driving this request. But I think the harder challenge I have, I mean, I think that there's been some suggestions about the possibility of a condition here, but just philosophically, one of the justifications is, that the proposal is consistent with the ordinance, but it's not consistent with the ordinance. There's a rezoning that's been requested for this site, which I guess is pending. As I understand it, from what we've heard this morning, the density that's proposed in this application before us would not be permissible under the existing zoning. Therefore, the rezoning is necessary in order to permit the density that's anticipated, which would then result in the need for the variance. So, my interpretation of that is that unless this site gets the zoning approval, there isn't necessarily the need for the variance. And so those are the 2 issues I'm struggling with. Having said that, certainly affordable housing, very important. Everybody understands that. The applicant, obviously, a seasoned applicant providing an important service. The agents are, well-versed, well-spoken, understand. We've been here before with them as recently as last meeting. So, I mean, we all understand this. I need some help with these 2 kinds of philosophical elements. 1, cost as the rationalization for the variance, and 2, the approval of a variance for a use that's not permitted under the zoning. And I look forward to hearing y'all's thoughts about it. Thank you.
Mike Tarrant.
Thank you, Mr. Chair. Mr. Meadows, I had similar considerations. I think when I look at the plan and what the applicants have presented here this morning, to me, it sounds like you could possibly modify buildings 2 and 3, but then they wouldn't meet fire code requirements. And so that my understanding is causing the split between those buildings and pushing the one building into the no build a little bit. So I think there are some constraints, and based on the previous meeting and presentations, I understand architecture isn't as easy as just simply modifying and tweaking and chopping buildings off and so forth. So I think there are some challenges with the land planning side of things. When I look at the findings of this particular property, as I believe Mr. Vice pointed out earlier, rarely do you see a triangular shaped parcel, which is challenging in its own right, but also being flanked on two sides with significant stream buffers. In addition to topography, I think it's just really very limiting and restricting and challenging on this site. So I think there is a hardship there that I feel I can fully support this application.
Thank you, Mr. Tarrant. David Paletta.
A few thoughts and observations. First, following up on Chad's observations, they make sense. I'm due to the peculiar conditions of the site that are have been pointed out well. I'm not really worried about the cost per unit issue. On how to weigh the more philosophical factors, I'm influenced a lot by the fact that one of the factors the applicant is trying to do is maximize units to address the goal of the need for more affordable housing units, which is a community concern, a community crisis. And that's a little variation of it's and different from simply trying to maximize a profit that we'll see in other types of proposals. Overall, I find the project a compelling project to address the community need of affordable housing. And I am persuaded a lot that the size of the variance requested is a very small, given the whole scope of the project. And so the applicant has adequately satisfied my concerns. Just wanted to put that out there.
Thanks, David. I agree with you. Any of the other board members? Any thoughts?
Rutchless here.
Mr. Rutchless.
I kind of agree with David Paletta. We're only talking about 0.03%. I think trying to configure a project like this, it's tough. That's why we have a variance. But it's also based on, the zoning. I am definitely in support of this under the need for affordable housing at this time.
Thank you, Mr. Rutchless. Anyone else? All right. This is a variance. We do not get a staff recommendation on this. Does anyone want to offer a motion?
I'll make a motion.
All right, David.
I move that case number B22-00007, an application for a request for a variance from the outer 50 feet of the 100-foot riparian buffer and 10-foot no-build setback on property located at 2120 East Gear Street, has successfully met the applicable requirements of the UDO and is hereby granted subject to the following conditions. The improvement shall be substantially consistent with the plan, with all the plans and information submitted to the board as part of the application. And a form of mitigation is provided similar to the options found in UDO 8.5.11A.
Jessica?
I'm sorry, could we change that condition to include language that this will be approved pending the approval of the zoning application or something along those lines, that this is approved, assuming that is approved and that what is approved is similar to what we saw today?
I will
Sorry to
add
make-
that to the motion.
Sorry to make it more complicated.
Chair Rogers, I added language if the board wants to use that for the condition that Jessica just mentioned.
Yeah, so David, there's a language in the chat. Would you like to add that to your motion?
Thank you. I would add this variance is approved. A condition would be the variance is approved with the condition that a rezoning that allows the proposed project is approved and is substantially in keeping with the submitted application. Thank you.
All right, we've got a motion by Mr. Paletta. Is there a second?
Retchless second.
Retchless on the second. Any discuss? Chad, you had your hand up, so was it?
No, it's resolved. I was going to offer an amendment to the motion, but that's taken care of, so we're good.
Got it. Amanda, would you like to call everyone?
Yes. All right. Meadows,
Yes.
Pauletta,
Yes.
Rogers,
Yes.
Retchless,
Yes.
Major,
Yes.
Terrence,
Yes.
Bouchane.
Yes.
Motion passes 7-0.
All right, by a vote of 7-0, your request for a variance has been approved. We thank you for coming before the bill, and we'll see you in a few moments.
Thank you.
Thank you.
All right, our next case, Amanda, do you want to call it?
Yes. B22000009, a request for minor special use permit for an educational use in a residential zoning district. The subject site is located at 1001 and 901 North Street, is zoned residential urban multifamily, RU-M, and in the urban tier. This case has been advertised for the required period of time, and notarized affidavits verifying the sign postings and letter mailings are on file. Seating for this case is Meadows, Pauletta, Rogers, Retchless, Major, Tarrant, and Bouchane.
Amanda, I believe Mike Retchless has recused himself in this case.
Okay. All right. So the seating for this case will be Meadows, Pauletta, Rogers, Major, Tarrant, and Bouchane.
All right, great. Chris, have you got something?
Yes, I was about to bring in, we already have our applicants in from the previous case, but we have a lot of individuals registered to speak. So if I can ask anyone who wishes to speak on this case to please raise your hand, and we'll be sure to bring you in for this case.
All right, yeah, that is a good point. If we do, we always ask this. Usually this is when we are in person, we ask if you are plan on giving similar or the same testimony, maybe appoint someone to give that. One of the things we've done in times before, if you support that, we as a show of hands or something like that, just to show that everybody's there. But we'll go forward with this. Everybody who plans on giving testimony in this case, for or against, will need to have their camera on to administer the oath. Cole?
Yeah, just before, staff did send an email to all the applicants, of the proponents, letting them know that if they did have someone that they wanted to elect as their speaker, that was acceptable. I don't think they were able to gather everyone's thoughts and consistency. So they may present individually, unless otherwise, notified in the meeting as such, just as a informational nugget.
All right. So again, everyone who plans on giving testimony will need your camera on, and we'll administer the oath, and we'll get this thing started. All right. I'll need everyone to raise your right hand, please. Do you swear or affirm the testimony you'll give today is the truth and nothing but the truth? David Smith.
I do.
Joe Fitzsimmons.
I do.
Dan Jewell.
I do.
Patrick Biker.
I do.
Richard Hall.
I do.
Helena Craig.
I do.
All right. And do you consent to this remote meeting platform, Helena?
Yes.
Richard.
Yes.
Joe Fitzsimmons.
Yes.
Patrick Biker.
Yes.
Dan Jewell.
Yes.
David Smith.
Yes.
All right. Thank you. Cole, I'll turn it over to you.
Thank you. Sorry about that. Give me just a few seconds. Good morning. I'm Cole Reniger, representing the planning department. Planning staff requests a staff report and all materials submitted to the public hearing to be made part of the public record with any necessary corrections as noted.
Noted. Thank you.
Case B 22-00007 is a request for a minor special use permit for an educational use and residential zoning district. The applicant is Robert Chapman and is in the city of Durham's jurisdiction. The case area is highlighted in red. The site is in the urban tier, zoned residential urban multifamily, RUM, and is within the city. The existing use is community service education and vacant community service. Robert Chapman, applicant, proposes a 300 student education facility to be located at 1001 and 901 North Street. The project is on 2.054 acre site, zoned residential urban multifamily and within the urban development tier. An educational facility in a residential zoning district requires the issuance of a minor special use permit pursuant to the UDO section 5.1.2, the use table, and is subject to limited use standards of UDO section 5.3.3K. A site plan, case D 21-00420, is currently under review this project and is included as an attachment to the application. The site plan is substantially clear of comments and no approvals have been issued at this time. And I see that Chad has his hand raised. And Mike.
Good morning. Thank you, Cole. Just a quick question for you. The staff report talks about a 300 student school. In the past, when we've considered these kinds of applications, occasionally we apply a maximum number of students. Has that been discussed with the applicant at all? I assume they'll talk about that. I just wanted to know if staff had raised that.
I don't believe staff has raised that.
Okay, thank you.
Mr. Tarrant.
Thank you. Good morning, Mr. Reniger. I just had a clarification. It looked like both the staff report and the applicant's summary indicate that no additional lighting will be provided. And then elsewhere, I believe I saw that it could be added if deemed necessary at a later date. And I'm just curious if we approve this special use permit based on the fact that no additional lighting will be provided, but then it's required later, will that require the applicant to come back before the board to amend or get a new special use permit?
So it's lighting, depending on how big the change is, they may be required to come back to the board, but that would come down to the plan director's discretion, whether the change was substantial enough to warrant that they return to the board.
Thank you.
This is Jessica Dockery from the planning department. I wanted to clarify for Mr. Meadows. I believe this is a charter school, and as such, as a public school, we can't limit the number of students. They're allowed to have as many as they're legally allowed to have per state educational rules.
Thank you.
Mm-hmm.
All right. Any other questions for Cole before we hear from the applicant? Seeing none, hearing none, we'll turn it over to, I'm assuming Patrick Biker or Dan Jewell.
Yeah, Mr. Chairman, can you hear us again?
We can hear you.
We're back. Did you miss us? Anyway, Chairman Rogers, Vice Chair members of the board, I'm Patrick Biker with Morningstar Law Group. My office address is still 700 West Main Street here in Durham. At the outset, Mr. Chairman, we'd like to ask that all the exhibits relied upon or referred to by our witnesses, including the staff report, which I thought was excellent in this particular case. All the attachments be moved into evidence. And we'd also like the resumes of Dan Jewell, Rick Hall, and David Smith, as well as a copy of Mr. Smith's real estate impact analysis admitted into evidence. I believe we submitted these to Cole a few days ago, and they're denoted as exhibits A, B, and C to be part of the record of this proceeding. If that's agreeable to you, Mr. Chairman, we'll get into our presentation.
Yes, it looks good. Yes.
Very good. Chairman Rogers, Vice Chair Meadows, members of the board, we represent Central Park School for Children, a public charter school which aspires to occupy a site containing 2.05 acres located at 901 and 1001 North Street in Durham. We're here today to request a special use permit for Central Park School for Children so it can occupy the historic North Durham grade school that TROSA has used for approximately 25 years. Throughout this presentation, we will often refer to Central Park School for Children as Central Park. And for the record, Central Park is proposing to use this location for its middle school, serving grades 5 through 8. In regards to our plan and the forecast of evidence, Section 3.9.1B of the UDO gives the Board of Adjustment final decision-making for all minor special use permits. As Cole said, the site is currently zoned residential urban multifamily, which allows for development of a school with approval of a special use permit from this board. The applicant will demonstrate that the proposed plan for Central Park meets all the requirements for approval set forth in the UDO through the exhibits and the testimony of our following witnesses, each of whom is an expert in his field. Mr. Dan Jewell is the president of CJTPA. He's a highly experienced landscape architect registered with the state of North Carolina, and he will testify in regard to most of the review factors listed in UDO section 3.9.8. After Mr. Jewell, Mr. Rick Hall will testify. He is the project's traffic engineer. Mr. Hall is a professional engineer licensed with the state of North Carolina with many years of experience, and he will address traffic and circulation issues. And lastly, Mr. David Smith is a duly licensed real estate appraiser, and he is a member of the Appraisal Institute, which is the highest designation available in the real estate appraisal profession. Mr. David Smith is the president of Smith & Associates here in Durham. Also in attendance is Mr. Bob Chapman, who's leading this development on behalf of Central Park, as well as our project architect, Mr. Joe Fitzsimmons with Belk Architecture here in Durham. In regards to the legal standards, as you consider this evidence, please keep in mind the legal standards which govern this type of hearing. It is our burden as the applicant to provide competent material, substantial evidence showing that each of the required approval criteria has been met. Once this is done, the applicant is entitled to issuance of the special use permit, and special uses are permitted as of right once the evidence shows all the applicable criteria have been met. We feel confident that the competent material, substantial evidence which will be presented today will establish clearly that the applicant has complied with all the requirements of the UDO, and therefore this special use permit should be issued. Prior to Mr. Dan Jewell's testimony, I would like to turn it over briefly to Ms. Helena Craig. My understanding is she's the treasurer of the North Durham neighborhood, and would like to welcome her comments in regards to this case, and then our expert witnesses will testify. So if you could turn it over to Helena, that'd be great, and then we'll turn it over to Mr. Dan Jewell.
Good morning, all. Thanks for allowing me a few moments. I just wanted to speak on behalf of Old North Durham Neighborhood Association. I reside at 523 East Gear Street. I do serve as a treasurer. Old North Durham represents a little over 800 households in the neighborhood where this project is proposed. The use has been discussed on our neighborhood listserv and in-person meetings, and our neighborhood association board has authorized me to express our support. The general agreement in the neighborhood, not that there's 100% consensus, obviously, is that the proposed use is in harmony with the area, not substantially injurious to the value of properties in the general vicinity. From general review of the plans for pickup for students, there have been some concerns expressed, but overall there's a recognition that if there's a neighborhood value that we would like to have neighborhood schools, that's necessary to have neighborhood pickups in the urban tier. So we do support that with some, some uncomfortability about that. However, we do trust Durham Central Park School to be a good steward and a good community partner. And to that end, we know that we can have conversations ongoing to make sure to perfect the pickup line, to work towards school traffic limiting signs as we progress along in the project. And I would say the only concern that has bubbled up is that we would like for the applicant to affirmatively commit that there is no plan to privatize the parking lot that is straddling 310 West Gear and the applied properties. But other than that, generally speaking, we do support this returning to a neighborhood school. Thank you.
Thank you, Ms. Craig. We really appreciate your time this morning. And with that, Mr. Chairman, I'll turn it over to our first expert witness, Mr. Dan Jewell.
Thank you, Patrick. Good morning again, Chairman Rogers, member of the board. I'm Dan Jewell, president of CJTPA, offices here at 111 West Main Street in Durham. Exhibit A, which Patrick submitted, does list my qualifications, but briefly again, received a degree in landscape architecture in 1981 from Purdue University. Have first licensed in 1983 and have been practicing as a state licensed landscape architect in North Carolina, primarily in Durham, since 1985. During that time, me and under my supervision, my firm has worked on literally dozens of public schools, including charter schools, both new schools and renovated schools, such as this one here, including Lucas Middle School, Sandy Ridge, Creekside, and others. My role on the team regarding this application is I oversaw the development of the site plan, which is now been reviewed by staff and is included in your agenda package and is part of the staff report. So what I'd like to go into now is discussion of the various review factors that are required for you to make a finding in favor of our request. Those review factors include lighting. Lighting will meet all UDO standards. Light fixtures will be added at exterior door entrances. Parking lot, pedestrian walkways, and service and loading areas will be lit appropriately. And at this juncture, there will not be any additional lighting being proposed. But as was said, we will need to meet the UDO standards for lighting. We will meet the minimum standards. Signage, no significant change to current signs. All will be in with compliance with applicable ordinance standards. Utilities, existing water, sewer, and power lines provide utilities to the site. Since the building is over 90 years old, the only utility we anticipate installing is a new fire line for a new fire sprinkler system in the building, which will come off of North Street. Open space, the proposed site plan complies with the UD open space requirements, and the total area of the proposed open space will meet or exceed the minimum UDO standard of 3%, and also 10% tree coverage is required as shown on the site plan. Environmental protection. There are no other types of natural features on this property, such as floodplains, streams, wetlands, steep slopes, things of that nature. So concurrently, we will not be impacting any of those features. The proposed site plan meets all relevant UDO requirements for impervious surface limitations and other environmental protection standards. Screening, buffering, and landscaping. The teacher and short-term visitor parking lot area, which exists today, will be landscaped with trees and shrubs that meet the requirements of the UDO, so will be an improvement over the current condition. Effects on nearby properties. In my expert opinion, there will not be a significant increase of noise, odor, or lighting at the site as a result of your granting the special use permit, with the possible exception of middle school students spending a little bit of time outdoors during the school day. Compatibility. The building has been here for over 90 years. it was built as a school. So its scale and design have been and will continue to be harmonious with the neighborhood. And consistency with policy, in my expert opinion, schools should be encouraged in the urban tier, especially when existing buildings are being utilized in a neighborhood which is exceedingly walkable. And of course, to reiterate, the building we are discussing today was built as a school in 1929. By the late 1970s, the school was decommissioned. Building was converted to offices for a while for Durham Public Schools. TROSA purchased the building in 1994 for its use in a residential education program. And so since this was built as a school and served as a school for 40 to 50 years, we think this is an excellent adaptive reuse project in recycling this building back to the use that it was originally intended and that the neighborhood grew up around. And there are no zoning overlay districts on the property, so there are no consistency issues with that. So in summary, in my professional opinion, based on this testimony, the approval of the special use permit by you will prove that we are in harmony with the surrounding areas because we are compatible with the existing and anticipated uses. We are adaptively reusing this 90-year-old building as it was originally intended for use as an education facility to serve Durham's growing population of school-age children, and that the application for the special use permit is in conformance with all special requirements applicable to the use for this site for a school under the relevant sections of the UDO, and in conformance with all the UDO review factors I previously discussed. Thank you. I'll be happy to answer any questions you have relating to my testimony, but if at this time there aren't any, I'd like to invite Mr. Rick Hall, our project traffic engineer, to speak a little bit more about our application. Thank you.
Good morning. My name is Rick Hall, and I am a registered professional engineer in North Carolina. I graduated from Virginia Tech with a bachelor's and master's degree in transportation, and I'm certified as a registered professional engineer in 18 states across the United States, working primarily in the transportation engineering and traffic engineering field. I am registered in North Carolina. I worked on all the traffic and circulation issues for this proposed school at this location. The site access points, there are two of them on North Street, two locations, very similar to the way the entrances have been for a considerable amount of time. In my professional opinion, it's the safest configuration that we could achieve. The site was originally developed as a school back in 1930, and when walking and biking was much more routine. So it still works well given the compact urban environment surrounding the school. Streets are excellent for temporary holding concerning parents and drivers that pick up and drop off the students to the school. Speeds are low in this urban area, and it's not a suburban neighborhood where faster speeds prevail, and a much greater concern needs to be exercised for the queuing that may occur for picking up and dropping off students. So the urban setting with lower speeds is much more compatible for the queuing that will occur. Around the building, adequate space has been provided to allow for emergency vehicles. The fire access and emergency access is adequately provided by the streets that go through the school property and exit to the south. School buses can freely circulate. Fire apparatus are a maximum of 8.5 feet wide, and the internal streets can handle those kind of vehicles without difficulty. The proposed new use of this old school will incorporate teacher and short-term visitor parking within the site, and that is deemed by me to be adequate based on the number of the faculty and the visitors that are normally appearing on the site. Bicycle parking will be provided to match UDO standards. Approval of this special use will have no significant adverse impact on the adjacent properties, as all the traffic associated with the new school operation will not adversely affect public health and safety.
Mr. Hall, Patrick Biker here. Mr. Hall, would you please provide just a brief testimony on the UDO criteria relating to service, entrances, and areas, please?
Okay.
If you just mention where the dumpsters are located and your expert opinion on the ease of access and safety.
Yes, the dumpsters are located on the northern edge of the building and driveway. Fully adequate width is available for trash pickup at those locations as required by the UDO.
Thank you, Mr. Hall.
Yes. The bottom line on this analysis for queuing is that the existing school operating to the south was measured in great detail, and the trip generation measured there was translated to this location, and the queuing for pickup and drop off of students is deemed to be adequate on the surrounding streets during the AM and the PM peak for school pickup. I'm available to answer any questions that anybody may have at this point.
We'll hold all questions until the applicant is done with their testimony.
Very good.
Very good. Our next witness will be Mr. David Smith.
Good morning. My name is David Smith. I live at 2007 Front Street here in Durham. I am a real estate appraiser, and I've been appraising property in Durham for over 40 years. I have the state certified. I also have the MAI and the SRA designations, which I think Patrick said are like the most highly regarded professional designations in the appraisal field. I'm a graduate of Duke University. I also attended public schools, and as an aside, my mother actually went to this school when she was a little girl because she grew up in Durham too. In order to determine if this property would have an adverse effect on property values, what we appraised, well, I looked at the plans, I went and looked at the site. The way that appraisers determine whether or not something has an adverse effect is we do something called a matched pairs analysis. So we find a property, in this case, near a school, and we find properties that aren't near a school, and we adjust them and compare them on a per square foot basis to see if you get a lower value on those properties that are near school or whatever you're trying to find. So I found a school, Spring Valley, over off of Sharon Road. I don't know if any of you are familiar with it, but it was right near the Bright Leaf developments over there. And there's one subdivision directly across the street. So I looked at the houses that sold in that subdivision, and I compared them with another one in Bright Leaf at the other end of the neighborhood that was nowhere near the school. And I made adjustments and got per square foot values. And based on those per square foot values, the houses near the school actually sold for more per square foot than those away from it. So based on that, it is my opinion that the proposed school will not substantially injure the value of properties in the general vicinity and will be in harmony with the area. I believe you have a copy of my report, and my resume is at the end of that report in Exhibit C. And I'll be glad to answer any questions you all may have, and I will turn it back over to Mr. Biker.
Thank you, Mr. Smith. Mr. Chairman, members of the board, again, this is Patrick Biker speaking, attorney for the applicant. At this time, we again reiterate for the record that we move into evidence all the exhibits relied upon or referred to by our witnesses, including the staff report and all the attachments. As mentioned at the beginning of this hearing, it's the applicant's burden to provide competent, material, substantial evidence into the record showing that the proposal meets all the requirements of the UDO for approval of this special use permit. In this case, we met this standard, and therefore we request approval of the special use permit so we can proceed with the development of the Central Park School for Children in order to serve middle school age students. All the competent, substantial material evidence in the record shows we've met the requirements of the UDO. Each of the findings in UDO section 3.9 were addressed by expert witnesses, and therefore on behalf of the applicant, we respectfully request your approval of this minor special use permit. Our team will be happy to answer any questions you have at this time. And again, we thank you for your time this morning.
All right, thank you. All right, I think we've got a few folks with questions. Chad, would you like to go first?
Thank you, Mr. Chair. Good morning, gentlemen. Three questions for you, just clarifications mostly, but I wanted to raise them. The first was, and I'm just going to give them to you in succession, and then you guys can answer them however you like. But the first one was, I just wanted a clarification that no additional lighting would be proposed. The second question relates to the additional parking area, the gravel parking area to the south of the building. There was a comment about parking lot landscaping. I understand there's some landscaping associated with the teacher and short-term visitor parking. I was hoping you could talk a little bit more about if the overflow or the gravel parking area south of the building is going to get landscaped. I didn't see anything on the plan with respect to that. And then finally, if somebody could talk just a little bit about what's anticipated in terms of vehicles parking on eastbound Trinity or on southbound North Street during loading and unloading times. I remember from days gone by that can sometimes be a challenge, and I'm just wondering what the thought process is about those three things. Lighting, landscaping in the lower parking lot, and what about parked vehicles in the loading zone? Thank you.
Okay. Vice Chair Meadows, Dan Jewell will get lead off on answering those questions, and then the second batter will be Rick Hall to address some of those traffic and queuing issues.
That's correct. Dan Jewell again. Thank you, Mr. Meadows. So relative to additional lighting, as I said in my report, the only lighting we're anticipating adding right now are some emergency lights at the entrances and exits to the building. Those are required by code, so those will have to go in. We are not anticipating adding any additional lighting as part of this application, nor was any shown on our site plan that the staff has reviewed. Relative to parking lot landscaping, yes, you're correct. The only landscaping we're adding would be to the parking lot on the North Street side, on the east side of the building near the front door, so to speak. And that is an existing parking lot. We are not proposing any landscaping to the existing parking lot on the west side of the building, which is, there's a property line that runs through the middle of that parking lot, as many of you know. Some of it is actually on the on this property. Some of it is actually on city property, part of the old North Street Park that is behind this building. So hopefully that answers those two questions. And as Mr. Biker said, perhaps Mr. Hall can address the question about effects to East Trinity Avenue.
Trinity Avenue will be used for the tail end of the queuing that may occur in the morning and in the afternoon. On the Trinity stretch, the existing parallel parking on that street can remain because the queuing will occur in the street adjacent to the parallel parking. So there's no interruption to the parallel parking activity on Trinity. Now, on the east side, there will be a need to have use of the lane adjacent to the curb that can otherwise be used for parallel parking during the non-pickup and drop-off times. So that'll be the situation on the east side.
One quick follow-on, if I may, and then I'll be quiet. Is there on-street parking on the opposite side of North Street?
I believe there is, yes.
Thank you.
Mr. Tarrant.
Thank you. I've got similar concerns, Mr. Meadows, just regarding the queuing and traffic congestion. Just, I've personally observed over the years quite a bit of congestion and issues associated with Immaculata and DSA, which are two schools in the general vicinity, coupled with the parallel parking on both on Trinity and North Street. I'm just not convinced that there aren't going to be significant issues during pickup and drop off, specifically pickup. And I did notice in the application there was a suggestion of a staggered pickup schedule, and I'm just curious, Mr. Hall, if you could just elaborate a little bit more on how this is being handled. So I'm not fully convinced at this point that there won't be significant issues during pickup and drop off.
Yes, there is available trip generation formulas for pickup and drop off in the state of North Carolina. The majority of the data that go into the queuing analysis for the state in general is done primarily in suburban schools, where the speeds are faster, and it's much more important to minimize queuing on those faster collectors and arterials. We have a different situation with the urban condition that exists around the school at Central Park. The streets are traveling vehicles are traveling very slowly on these streets, and therefore any mismovement by a pedestrian or another automobile will be taken care of by the ability to react due to the slower speeds that are moving. No one will travel by on either of the two streets at 45 or 50 miles an hour. There will all be slow-moving traffic that comes into the realm of the queuing. Also, the queuing happens at very well-known time periods. I mean, to the nearest 15 minutes. So users of the fine-grained grid street system in the area have plenty of opportunity to avoid these streets if they personally feel that they would experience congestion on these two streets. But for the majority of the vehicles that will pass by during these very slim time periods of picking up and dropping students, the situation is, in my professional opinion, very safe and very much compatible with the urban character in the downtown area. It's not a suburban school, it is an urban school, and traffic will operate in accordance with the typical operating situation that drivers experience in a fine gridded system in the classic sense around the school.
Thank you. And one final follow-up. Has there been any consideration to additional signage, perhaps limiting parallel parking, on-street parking during pickup and drop-off times at all to perhaps improve potential congestion?
Mr. Chair, I don't mean to interrupt, but Earlene Thomas from City Transportation actually wanted to speak to clarify that question about the stacking and parking and how that will work. If you all will allow her to unmute and respond.
Yeah, I think that's
great. Thank you.
Will she go ahead now?
Okay.
Yes.
She's working on it, looks like.
Good morning, Earlene Thomas, City Transportation Department. So to be able to allow on-street parking along both Trinity and North in compliance with the general statute that was passed, the city will need to remove all on-street parking in those areas such that traffic operations will not be impeded. We did consider some time periods for no parking, but you always run the risk of someone still being parked there and blocking sort of that queuing lane. So the city will be removing the on-street parking.
Right. Mike,
Thank you. And I guess to follow up to that checks one box, but then I have concerns with some of these older neighborhoods that rely on on-street parking, and does that create any issues with the existing homes along Trinity and North Street as it relates to parking for their private residents?
Mr. Chairman, if I may respond to the parking.
Sure.
It would be more smooth for all the operations to have the parallel parking on North Street not happen during the AM and the PM periods. However, both North and Trinity can maintain their parallel parking with no significant impact to the traffic flow in the area. As I said, North has a very low volume. Trinity has a moderate volume. So the grid system of streets allows all drivers within the whole region to understand that the pickup and drop off periods, very narrow periods, 2 times a day, are times they should avoid being in that grid system if they so choose. But I think to remove the parallel parking on Trinity would not be a good idea. There is plenty of room in the existing laneage next to the parallel parking on Trinity to let it remain 24/7. Because there is a higher density of land use adjacent there, and the parallel parking would be very helpful to the corridor on Trinity. And regarding the potential of someone blocking the north corridor, the signage and enforcement are the answer to making sure that nobody stays for a very long period of time during the pickup and drop off along North.
And Mr. Chairman, if I may add one point, all the residential along Trinity is, ironically, it's owned by Leah Bergman, who was just sitting next to her. But it has off-street parking for the residents there. So those buildings, it appears, do not rely on on-street parking. There's plenty of off-street parking in the parking lots adjacent to those multifamily buildings along the south side of Trinity Avenue.
All right. Mike, was that all that you had on that?
It is, thank you.
Okay. Mr. Meadows.
Thank you, Mr. Chair. One last question. This is actually for Mr. Jewell. In thinking about the campus on Hunt Street, ultimately the drop-off queue sort of goes down the alley and folks turn right onto Hunt Street and drop off. Did the school look at all at the possibility of using that sort of vehicular travel way that would be created by a realignment of the driveway? I understand today that there's some storage and so forth in that area. It's impossible to get around the back of the building. It looks like that's going to change. Was that explored at all, the possibility of sending the queue around the back of the building? Did you guys look at that? And if so, what was the determination there?
Yeah, I'll start, and Mr. Hall or Mr. Fitzsimmons might want to chime in, but we did look at that as an alternative and felt that that was not the safest or most efficient option for folks to be circling back, mostly because we could have ended up with a situation where folks were queuing up around the back and north of the building, and then conflicting with more folks trying to come in and out. So we ended up with some potential turning in, turning out through conflicts. And Mr. Hall might want to add to that a little bit as well.
Yes, the use of the lane that's on the north and the west sides of the building for pickup and drop off would confound the movement of vehicles through that area. There would be a great tendency to get mixed up with the bus circulation activity that will happen along those lanes. So we did look at both, and we decided that to have the pickup and drop off drivers continue southbound on the east side on North Street would be the safest overall condition for students to board and alight from cars on north, and then move to the school from an opposite area than any of the bus or faculty travel is going to take place. I might add that removal of parallel parking will increase the speeds on both Trinity and North, especially if it's done all day long. And we do not need speeds to increase on these fine classic urban streets that are used for walkability. Many of the students that arrive at the school will be walking to the school. So a removal of the parking is damaging to the safety of the use of pedestrians in the entire 3-block area, and therefore we'd certainly recommend that you only have temporary removal of parking on North and leave the parallel parking on Trinity the way it is today.
All right, anything else, Chad? I see you started. Okay. All right, any other questions for the applicant? All right, is there anyone else here to speak in favor of this application for a minor special use permit? Is there anyone here to speak against? I saw a hand up. I'm sorry, just quickly, I didn't catch it.
Chair Rogers, this is Jessica Dockery from the Planning Department. I just wanted to be clear that the parking will be removed. The parallel parking will not be in place. I know that Mr. Hall was making comments about that. I just want to be clear that the site plan is showing that parking being removed.
Okay. All right. Again, anybody here, let me say this, anybody else here to speak in favor of this application? And now we'll move to anybody here to speak against this. Hearing none, seeing none. All right, Cole, do you have a recommendation for the group? Do I see Cole? Cole's no longer with us. There you
No,
go.
I'm here. Sorry. Took a second. Yeah, staff recommends approval with all the submitted materials made at the public hearing.
All right, cool. Thank you for that. All right, let's bring it back to the table. Any thoughts or discussion on this? Mr. Meadows?
Love the proposal. Fantastic. I think it's great to get that building back into a school use. Definitely support this.
Mr. Terry?
I agree with Mr. Meadows. I love that they're preserving the old structure. I think they've done a great job, they being the applicant, just preserving almost in its entirety the campus. And I think that speaks volumes to maintaining the harmony of the area. Obviously, traffic concerns are always an issue with schools. Urban areas are challenging, but I believe the testimony provided this morning does an adequate job addressing those within the ability to do so. So I appreciate the effort that went into this project and the testimony provided this morning, and I support this application as well.
Thanks, Mike. David Paletta.
I like the proposal. I like the concept of the proposal, using this historic school, getting it renovated. I was curious if there were going to be any neighbors who objected, because it really seems like a good thing for the neighborhood. There is going to be some inconvenience with the pickup and especially pickup. But overall, that's true in every case. So, and I believe the applicant addressed the relevant criteria. So I'm comfortable with this project.
Thanks, David. Anyone else? Board members? And I have to agree with y'all. This is well said. It's kind of easy for the chair to hear from all of you. You say everything that I can't really add much to that. So, all right. Does anyone want to make a motion?
I'll make a motion.
Mr. Meadows.
I hereby make a motion that case number B2200009, an application for a request for a minor special use permit for an educational facility in a residential zoning district on property located at 101 and 901 North Street, has successfully met the applicable requirements of the Unified Development Ordinance and is hereby granted, subject to the following conditions. 1, the improvements shall be substantially consistent with the plans and all information submitted to the board as part of the application. 2, the educational facility shall serve 6th through 8th grade levels. And 3, any outdoor areas to be utilized by the school shall be shown on the associated site plan.
Right. We have a motion.
Mr. Chairman, it's going to be grades 5 through 8.
I amend my motion to alter that condition to read as follows: the educational facility shall serve the 5th through 8th grade levels.
All right, we've got a motion. Thank you. All right, we've got a motion for approval by Mr. Meadows. Is there a second?
Beauchesne, second.
Natalie Beauchesne on the second. Amanda, we'll turn it over to you.
All right. Meadows,
Yes.
Pauletta,
Yes.
Rogers,
Yes.
Major,
Yes.
Tarrant,
Yes.
Beauchesne.
Yes.
Motion passes 6-0.
Vote of 6-0, your request for a minor special use permit has been granted. We appreciate you guys coming for the BOA this morning.
Thank you very much. We appreciate all your time.
Thank you. All right, guys, we're at 10:18. Do we want a 5-minute break? I'm seeing some nods. Let's do that. We'll return. Actually, let's do 7 minutes. We'll return at 10:25.
To all of our attendees, as we return, I will be just promoting all the individuals for the next case B 22-00010. So please, if you receive a promote the panelist invite, please accept that for our next case. Thank you.
All right, for all of you who plan to give testimony on this next case, we'll need to have your camera on to administer the oath, and as soon as Mike Retchless gets back, we'll get this started. Ah, he's here. All right, so I'm looking around. Damian Bell, Michael Cardinal. If you do plan on speaking, we'll need your camera on. All right, well, we'll start. Please raise your right hand if you plan to give testimony. Do you swear or affirm the testimony you'll give today is the truth and nothing but the truth? Mr. Halpert?
I do.
Michael Allen? You're on mute, sir.
Sorry, I do.
Colin?
I do.
Toby Coleman is an attorney, so I don't know if we really need to swear you in. Damian Bell, are you planning on giving testimony?
Yes. Can you hear me?
Yes, we can.
Okay. It's telling me that I cannot start my video because the host. Okay, there we go.
All right. Do you swear or affirm the testimony you'll give today is the truth and nothing but the truth?
I do.
Ben Litke?
I do.
All right. And do you consent to this remote meeting platform, Ben?
Yes.
Damien?
Yes.
Colin?
Yes.
Michael?
Yes, sir.
Toby?
Yes.
Avi Halpert?
Yes.
All right. I think I got everyone except for Michael Cardinal. I don't know if he plans on speaking. Here, she. All right. We'll move forward. Cole?
Can you chair? Good morning, I'm coordinator representing the planning department. Planning staff requests the staff report and all materials submitted at the public hearing to be made part of the public record with any necessary corrections as noted.
So noted, thank you.
Case B 22-00010 is a request for a minor special use permit to allow for a helipad. The applicant is Michael Allen. The case area is highlighted in red. This site is in the suburban tier zoned Science Research Park and is in the county of Durham's jurisdiction. The existing use is industrial pharmaceutical health. Michael Allen, applicant, requests a minor special use permit to allow for a helipad in the SRP zoning district. The previous use is a pharmaceutical health facility, and the helipad is in addition to this facility. SRP districts do allow accessory use helipads with a minor special use permit. The helipad will be used for transporting staff and organs. It will include 2 pilot rest stations, flight operations center, and equipment storage. Per Unified Development Ordinance, UDO section 5.3.7A, helipads are allowed as an accessory use with approval of a minor special use permit. Staff is available for questions during the presentation.
Thanks, Cole. Any questions for Cole before we hear from the applicants or applicant? All right, hearing none, seeing none, we'll turn it over to, I'm not sure who from the applicant side is trying to.
I'll start.
All right, Mr. Coleman.
Good morning. My name is Toby Coleman. I'm an attorney with Smith Anderson. We've got offices in Raleigh. I'm actually Durham resident, 2702 Stewart Drive. I am here on behalf of the applicant, United Therapeutics, seeking a special use permit, as Cole outlined, for this helipad that's on the screen. We have a number of people here, mainly we've got a few people that will be speaking. Avi Halpert with United Therapeutics, Damian Bell, who's an acoustical engineer with SLR, and Ben Litke, who is a broker with Cushman and Wakefield. We're doing that to address the various aspects of the special use permit factors that I believe Mr. Biker outlined pretty ably. I won't, and standards, et cetera. I'm not going to repeat that unless needed. I'm going to kick it off just by giving you all sort of an overview. Cole, I'm not sure if this is the PowerPoint version or if this is a PowerPoint or if this is a PDF version of the PowerPoint. But if you could go, perfect. Okay.
Yeah, it's a PDF version of the PowerPoint.
Oh, okay.
Yeah.
So here's the overview. I mean, basically, I'll be giving the summary. Avi Halpert will give a overview of what the heliport's going to be used for. It's a pretty cool thing. United Therapeutics is working to manufacture organs at this site, and so this would be a heliport used literally to help transport organs to patients for transplant. We do have a couple folks who we're going to ask to testify, as I mentioned, and that's Damian Bell with SLR and Ben Litke with Cushman Wakefield. And then we have a couple, any additional information we can provide. If you go to the next page, cool. So here is the site location. The star is where this is actually sort of looking, I think this is sort of north, sort of not quite north. If as the crow flies, this is, I think, looking a little bit more east than north. The star is where is the old parking lot on the old GlaxoSmithKline campus where the helipad is proposed. Just for your background, United Therapeutics it operates currently in the building that fronts TW Alexander Drive with the white flat roof there on the left of the screen. They're a biotechnology company with a headquarters in RTP and another in Silver Spring, Maryland. You may be familiar with the building if you've driven by it. It's got a large sculpture of a couple of lungs out front. Their RTP facility already employs about 400 people. And a few years ago, they bought the GlaxoSmithKline campus at 2 Mon Road. It's 132 acres. With plans to expand its operations in the park. Again, as I noted, the plan here with the helipad is part of its plans to actually, it's part of its efforts to both manufacture organs and then help end the shortage of transplantable organs throughout the country and the world. This is a real innovation in the area. It's part of a long history of innovation actually at this site. You all probably know this. I actually didn't know this until I started getting involved in this site, that when, previously, this site was where the AIDS drug AZT was invented. So this is really a, pretty cool history here. And a project that, frankly, a land use guy like me doesn't always get the chance to be involved in. If you go to the next page, yes. So just to sort of further underline what Colin outlined for you, here is the we provided the site plan, which you saw earlier. It's taking that old parking lot and putting a helipad, as you can see the elevation there. It's relatively small. The plan is to actually have the helicopter landing area on the second, sort of on top, and then have 4, they'll be raised with small buildings below with 2 pilot rest stations, a flight operations center, and equipment storage. Now, this is designed both to service traditional helicopters. The vision for the future is ultimately to have it flying drones in and out. If you go to the next slide, or next page, I guess. And so the plan again is that these will transport organs. So organs manufactured at that facility. Ultimately, United Therapeutics is working on that now, has done some proof of concept, and Avi's going to outline a little bit of that in a minute. The goal with, just so you may be wondering, well, why do you need helicopters? Well, there's a lot of logistical barriers for organs. I see that Commissioner Meadows, Board Member Meadows, has his hand up. Happy to answer any questions if you have questions popped up now.
Please proceed. I'll wait. Yeah.
Okay.
Thank you.
Yeah. The goal is to get organs to people fast, reduce the need to have teams of doctors, reduce the need flying with things, reduce the need, delays and things like that. If you go to the next page. So in terms of harmony, which is one of the standards and the criteria, and I'm going a little bit out of order in terms of your classic criteria, but this is the first one. This property, as was mentioned, as Cole mentioned, is zoned SRP. So it's really limited to industrial and R&D use, and it's in the heart of RTP, and everything else around it is zoned SRP, and the future land use map calls it, for all of it, to be used for research and research applications. This green area shown on the map that you see is area zoned SRP. It's the park. So this is right at that, right at the intersection of, right where basically Cornwallis is running north, and then you've got 147 running alongside, and it's really in the heart there. Just want to highlight an aspect of the staff report. Most of the uses are industrial facilities with heavily wooded areas and large right-of-ways, and this accessory use fits within the subject property and has little impact. So that's straight from the staff report. Thought that was a useful item to mention. If you could go to the next page. In terms of public health and safety, I do want to mention a few things. First, that the heliport is subject to FAA oversight, particularly in terms of approach paths and location, which ensures no adverse impact to safety, and that FAA is in the process of finalizing approval for this helipad. You can see the map there. It shows the setbacks from all the nearby property lines. There's no property line closer than 825 feet to the helipad, so there's significant buffers. And a lot of those are further buffered by mature trees, plantings, the solar field there. There will be lighting on the helipad, but one of the really interesting things about the way this lighting is designed is it's going to be basically remote controlled. So it will only come on when helicopters or drones are arriving or departing. And finally, it will have access. It's going to take access from Maughan Drive, which is sort of on the southern end of that green area there. It's going to be gated and controlled to provide further security. Finally, so before I hand it over to Avi, I just want to do a couple of housekeeping items. We do want to introduce this entire presentation and evidence. We also submitted a vertiport noise impact study dated March 11th by SLR, which Damian Bell will refer to. Want to make sure that is admitted into evidence as well. And with that, I'll hand it over to Avi Halpert.
Great. Thank you, Toby. And Cole, if you would advance it one slide, please. And Cole, it's nice seeing you after all the email correspondence, and I appreciate all your help facilitating our presentation and the application over the past several months. A quick little history about United Therapeutics. Truly a passion of love and care. Dr. Rothblatt's daughter at age 7 was unable to breathe on a family vacation. Dr. Rothblatt went into parent mode, as we all would if we had a sick child. and took her daughter down to Children's National Hospital here in the Washington, D.C. area. I'm actually based in Silver Spring, Maryland. While Genesis, her daughter on the right of the screen, was being seen by various doctors. Dr. Rothblatt was in the hospital library at the time, which I went back just recently. It's actually a cafeteria today, but she has fond memories spending hours in the library researching what she ultimately determined that her daughter had pulmonary arterial hypertension. She located a molecule that was actually developed by GlaxoSmithKline at the 3030 East Cornwallis site where we're looking to place this helipad. She went there and petitioned them 3 times to obtain rights to this molecule. This molecule opens up the artery from the right side of the heart to the lung. It gets constricted in patients who have pulmonary arterial hypertension. After 3 tries and taking her nonprofit that she had set up and making it into a for-profit company, she was given a formula and she gave them $25,000 and 6% of revenues for the next 20 years. While our therapies for pulmonary arterial hypertension extend the life of our patients throughout the world, only a lung transplant is a known cure at this time. Dr. Rothblatt's vision for the next 20 years is to manufacture and make available an unlimited supply of organs for human transplantation. She does not believe that anybody should have to wait on a list anywhere in the world, and especially here in the United States, for a lung transplant, a heart transplant, a kidney transplant. If you have seen recently in the news, it was our pig heart that kept a patient alive up in Baltimore for 60 days. We've done subsequent testing on kidneys, both in New York and Alabama. And again, we are hoping to make both pig lungs, kidneys, and hearts, as well as manufactured lungs, hearts, and kidneys available for human transplantation. I've probably gone on too much, but I could talk forever about it, and it's fascinating. Cole, if you could go to the next slide. Martine has multiple shots on goal. She doesn't believe in team A and team B. We have team A, B, C, D, and for all I know, somewhere in our facilities, we have E, F, G, H, and I, but we have a process in Florida and in Silver Spring where we take human organs and assess them outside of the body. And the first one, the EVLP process, where you see a lung. And to date, there are over 250 people walking around that would otherwise not have a chance at this FDA study to expedite a human lung transplant into a living being. As previously stated, our xenotransplantation and our regen, where we're taking pig kidneys, pig lungs, and recellularizing them and creating custom lungs. And then likewise, we have a 3D program where we are printing 3D organs and taking human cells, seeding the organs, and we are doing studies on that right now. So multiple shots on goal, and again, all with the patient in mind. Next slide, Cole. Martine envisions a network of these helipads and vertiports, ultimately at a distance of about 100 miles between each of them. We are currently looking at electric vehicles, but until those are FAA approved, we are looking to create the helipad to take the organs that we are studying down in our RTP facility to different research facilities, including one of ours in Blacksburg, Virginia. Next. Well, this is a little bit beyond my real estate expertise. So Toby, I'll let you dictate who's next on the queue.
Thanks, Avi. Yeah, so up next, we did want to address, in terms of the criteria, we think we've met a lot of it, but we did want to go ahead and present evidence, both related to neighboring impacts, both in terms of acoustical sound issues and valuation. So first up is Damian Bell. He's an acoustical engineer with SLR, and as I mentioned, he prepared a report, the Vertport Noise Impact Study, which is in your file, dated March 11th, 2022. Damian, I'm going to hand off to you. If you could just kick off by providing your bona fides and then summarize the report.
All right. Yes. Thank you, Toby. Thank you, Avi, very much, and the board. My name is Damian Bell. I'm a senior acoustical engineer with SLR. I have roughly 15 years of experience conducting environmental sound surveys, outdoor noise, we call it, related to transportation, such as roadway, rail, and of course, aviation noise. And I have a degree in mechanical engineering with an emphasis or concentration in acoustics from the University of Hartford in Connecticut, and I am based out of New York State. So this is the, we prepared a full, comprehensive technical report, which I believe, Toby, a copy of that has been provided, which details our methodology and our findings in great detail, more so than time allows, but we'll try to summarize the findings here. I think we can advance to the next slide. Or actually, I think it was
well, if you could go back to the
first
other
slide.
PDF.
Yeah, PDF. Yeah, that's just the report for people's reference. So the slide that was shown just after Avi stopped speaking with the helicopter.
Yeah, I believe it's in the file titled PowerPoint presentation there.
There we go. You can go back to the previous slide with the red. There we go. So what we did is we assessed noise attributable to the proposed helipad vertiport. And we did this with a combination of computational modeling and actual sound measurements in situ at RTP and in the closest residential areas. And the modeling is based upon a program that's used by the FAA for land use and permitting for mostly larger airports. So if you want to expand a runway or something like that. And we used this tool, which also has a module for helicopters, rotorcraft, as we call it in industry, which has a whole library of different helicopters that you can model, and you put in a physical flight path, and you program in the speed and the angle of approach and things like that. And the model creates for you various what we call metrics. And the metric that we're most focused on here is something called the day-night level, referred to as DNL. And the DNL is really the most commonly used metric by the FAA and also agencies such as HUD for determining compatibility with residential use near an aviation type facility. And the day-night level, you can think of it as a kind of a long-term average sound level. So as you go through the course of a day or week or year, you're going to have all kinds of fluctuations in the ambient sound due to any number of things. And if we introduce the helipad and the vertiport, it will be one more thing contributing to the overall day-night level in the vicinity. So you can advance to the next slide. So we did this modeling of the vertiport, and in combination with that, we conducted 4 days of what are called ambient sound measurements in RTP and in other areas nearby, including the closest residential area, which is, I think, about 1/8 of a mile to the southwest. It's just on the south side of I-40. And that's really kind of the most important location because there's a preschool there and there's some homes. And we want to make sure that future sound levels from the proposed vertiport helipad do not exceed the FAA or the HUD criteria for residential land use. And that threshold is the day-night level of 65. So we measured, the first column shows the existing day-night levels based upon our multi-day sound measurement survey. They hover in the mid 50 to 55 dBA range DNL. And then the second column is the contribution from the helipad vertiport. And we see a contribution of 35 DNL at the location with the closest residences. So really what the findings are that there wouldn't be any kind of adverse noise impacts. And all of the other locations, even though many of them are commercial inside RTP, still stay below the residential standard of 65 DNL, which is important. So we're basically applying a somewhat stringent residential standard to a commercial industrial area, where we could have higher sound levels because more robust construction, most homes are made out of timber frame materials with operable windows and things like that. So the 65 DNL applies, whereas at industrial or commercial areas, we could probably live with 75 DNL, much higher noise impacts. So, and the county noise code, it really is just, it prohibits unreasonable noise. And so we wanted to use a quantitative accepted standard, being the FAA HUD standard, to determine whether there would be any adverse noise impacts. And we don't see that particularly given that the closest homes are almost a mile away. And by the time the helicopters are flying over that area, they've reached quite a higher altitude. So you're getting a much better distance buffer. So we don't anticipate any issues with sleep disturbance or general community annoyance due to flights passing by. And you can go to the next slide. It just kind of summarizes. We don't see significant increases in the DNL, nearby residences, or any sleep disturbance. And just to keep stressing that the overall, even inside RTP, we don't expect the DNL, the day-night level, to go above 65 dBA, which again is a residential standard, which is fairly strict for a commercial zone.
Thank you, Mr. Bell. Finally, in terms of evaluation impact, I'd like to ask Mr. Litke to speak. Mr. Litke is with Cushman Wakefield. Ben, if you could give your bona fides and then just summarize what you've done and your thoughts for the board.
Yeah, certainly. Thanks again. I'll echo everyone for their time and attention here. As Toby mentioned, my name is Ben Litke. I'm a senior director at Cushman & Wakefield. We are a global full-service commercial real estate firm. I sit here in Raleigh, Durham. Our office's address is 3015 Carrington Mill Boulevard in Morrisville. I'm a licensed North Carolina real estate broker, active member in the Triangle Area Office Building Association, National Association for Industrial and Office Parks. I've got a decade of experience here representing tenants and buyers in the Raleigh-Durham area. My practice focus really is Durham, RTP, and the I-40 corridor. Just based on my review of the project and the data shared today and my experience in RTP, the proposed enhancements to United Therapeutics campus do not impose any adverse effect to the ability for adjacent properties to achieve maximum sale or lease value should they be brought to market. The research and development nature of the project aligns well with other occupier objectives in the park. And the existing and projected demand in RTP for office and R&D facilities paired with the recent and frankly considerable increase in land values in RTP over the last 12 to 18 months have all factored into that recommendation.
Thank you, Ben. Again, we have presented this evidence to meet the criteria for a minor special use permit. We are all available for questions. We believe we've presented evidence meeting all the criteria, including the review factors outlined in 3.9.8.b. Happy to answer any questions.
All right. Excuse me. I don't think I've ever done this, but I skipped a few steps at the beginning, and I need to have Amanda call the case and clarify seating for this case. I've never done this before, but or never had this issue, I don't think. But Amanda, would you mind doing that?
Okay, yes. Can you hear me?
Yes.
Okay. B220010 County, a request for a minor special use permit for a helipad in an SRP zoning district. The subject site is located at 2 Morgan Drive, is zoned Science Research Park, SRP, and in the suburban tier. This case has been advertised for the required period of time and notarized affidavits verifying the sign postings and letter mailings are on file. Seating for this case is Meadows, Pauletta, Rogers, Retchless, Major, Tarrant, and Boucher.
Thank you, Amanda. All right. I've got one question, and Chad, I know you've had your hand up and you've got a couple as well, but just a point of clarification. Ben, are you a licensed appraiser?
I am not a licensed appraiser, no. I'm a licensed real estate broker.
All right. I know one of the things we take testimony from brokers often, but I mean, I think to speak directly on, property values, we have to take testimony from a licensed appraiser.
Mr. Rogers, could I speak to that?
Okay.
So the statute does not require, it requires expert testimony. It does not require an appraiser. Rather, it requires testimony from an expert that a court would find to be credible. Given Mr. Litke's experience and knowledge, I believe he qualifies. And there's multiple examples of brokers being used in this context. I would also note that, again, I don't think that it's really a question. We're presenting it as terms of valuation impact, but I do want to note that 160D does not specifically require an appraiser.
Understood. All right, Mr. Meadows, you have questions?
Jacob?
Yeah, Mr. Wardell, yes.
Yes, on that issue, I would certainly agree that the testimony is acceptable testimony from a broker. And so there's really no problem with regard to accepting that testimony into evidence in this case.
All right. Mr. Meadows?
Thank you. And still morning. Good morning. Fascinating stuff. Really, really interesting. I have 5 short, easy questions for you. I'm going to just say them and then I'll, however you guys choose to answer them. I am interested in understanding a little bit more about the rate of departure from the facility. It looked like the acoustical studies contemplated one event per day. And so I wasn't sure if we were talking about one helicopter per day, or if this could potentially be multiple. Next question is whether or not rotary aircraft used by other companies other than United Therapeutics would be using this facility. Third question is, if I understood the testimony correctly, the utilization of the heliport is for study purposes, not necessarily for life safety, rather that I understand it's expedient to get test material or products or whatever it is, that needs to be expedient. But I just wanted to clarify that this was all for study. Next question is with respect to the acoustical study and whether or not there is a cumulative noise impact, a DNL impact from multiple vertiport events, or the potential for additional noise from queuing of drones or helicopters, in the event that this takes off, which it certainly sounds very interesting. Finally, there was a notation that this facility is anticipated for daytime only operation, and I wanted to ask a quick clarification about whether or not that included weekends, or was it rather just normal business days. So those are my questions, and I will appreciate your answers in whatever sequence you'd like to give them. Thank you.
Sure. So Mr. Meadows, thank you for your questions. I'm going to start and then I'm going to hand it over to Avi Halpert, because he knows a lot about, he obviously is with United Therapeutics and is the best position to talk about the operational. And then we will probably hand it over to Damien to talk about the acoustical study. So you had a couple of questions in terms of departure timing and rate of departure. Even though this conclusion here says daytime only operation, I want to note that what that means, and Damien can confirm this, is that they studied daytime only operation, but based on their results, they did not see any impact from nighttime operation on sleep disturbance. And so the plan is, frankly, to have, the expectation is that it would be currently, once it starts up, it would be a few times a week. Obviously, they would need to leave when they need to leave. But it would not, I think the rate of departure at this point is a little bit up in the air, but it'd be a few times a week, I think, is the expectation. Avi can speak to that. And I'll let Avi speak to you'd asked about whether others could use it. One thing I will note is that while we outline what's currently that the organ transplant and organ production is currently under study, the utilization of the heliport is part of an envisioned network for actual life safety and life-saving purposes. So the goal of this heliport is not just for study, and it's to be part of a network and be, frankly, to have a facility that's producing organs, and then have that heliport be a ground base for taking the organs to hospitals. And with that, I think I've addressed some of your questions. Avi, could you address some of those as well?
Yeah. So, Mr. Meadows, with regarding use by others, it will only be for insurance purposes. It'll either be UT owned or UT facilitated drones. So our own aircraft that we currently own and operate ourselves, or when Martine's vision of electric vertical takeoff vehicles comes to fruition, it could conceivably be a fleet of these electric vehicles. Again, all controlled and under the direction of UT. We're not taking executives from RTP to RDU. It's entirely the entire purpose is to take the research, current research, and hopefully one day a commercial facility that we're currently designing in our master plan from RTP to whether it's a area hospital to one of our own facilities. But I think that answers by others. As Toby indicated, currently the plan is only daytime, might involve weekends where we're doing research on organs at our facility at Tumon Drive, immediately adjacent. And they're doing research studies in animals in Blacksburg and some other areas. And again, you know, currently you're right, R&D, but ultimately this is intended to be part of our commercial operations that we plan on locating within RTP. I turn over to my colleague who knows about acoustics and cumulative and multiple events. So I'll let SLR address that.
Yes, hi. So I guess first you'd asked about queuing. The modeling program does account for hovering and time above the actual helipad and how long it would take to actually ascend. So it accounts for all the operational components of a typical approach and then departure. As far as we used one event per day, an arrival and a departure. If we increase that to 10 events per day, which would be probably very beyond what would actually occur, we would still stay below the 55 DNL threshold, 65 DNL threshold, excuse me, at closest residences. We could have one nighttime event, departure, arrival departure, and still stay below the 65 DNL at the residences as well. But I don't think that will be very common. So we assumed just daytime operation for the modeling. Cumulatively, we did measure existing background sound levels or day-night levels, and already the sound levels in the area are in the 53 to 55 DNL. So, we account for that when we say how much would the future DNL be if the proposed facility were in place. So we do account for the cumulative DNL in the future with helipad and existing conditions. I don't know if that answers all of your questions.
It does. I was the intent of the question was to contemplate what the world might be like in terms of sound if this technology took off, if this became very, very popular, and we were at a place where there were multiple vehicle operations happening continuously, where you might have one drone that's getting ready to leave and two more drones circling around waiting to land, and what the combined impact of that traffic might be. And I understand that's not what you studied. I'm just wondering if you had some ideas about what that might mean with respect to cumulative DNL.
And Damien, when you're talking about it, one thing you may want to do, to the extent you can, is if there's any distinction you can draw between I believe you studied Bell helicopters versus the drone.
Yeah. The study assumed a Bell 429, a commercial helicopter. The preliminary information for the drones, we're calling them EVTOL, EVTOL, are that they are much quieter than traditional helicopters, possibly on absolute terms, 7 or 10 decibels quieter, absolute terms. We didn't necessarily model noise from the EVTOL. We used the worst case, the Bell 429. And what as I said before, we could have up to 10 total Bell 429 events during the daytime hours and still stay below the 65 DNL at the closest residential areas. We would probably require some additional analysis to give you the exact number. If we had a comparable number of EVTOL events, it would still stay below 65 DNL, but the degree to which that is the case, we would have to do a closer analysis. So we really did use a worst case noise source to make the analysis more straightforward. Given that the drones are experimental, we have noise data for them, but they're not approved by FAA, so they cannot be put into the modeling program. That's the kind of the issue.
Thank you.
Mr. Meadows, just one clarification. So we've filed with the FAA for what's called a prior permission required heliport. This will be privately owned and operated, and will require the necessary clearances both by the crew on the ground as well as the FAA before anybody can land or take off. So just wanted to clarify that one point. In the future, when hopefully this vision of Dr. Rothblatt materializes, the organs that are manufactured will be scheduled. So, we know that along a kidney, a heart is going from point A to point B. So that should eliminate the hovering or anybody waiting around to land a vehicle.
All right, Mike Tarrant is next.
Thank you. I just had one clarification pertaining to landscaping and buffering and perhaps environmental protection. It appeared in the application materials that no additional landscape buffers or tree coverage, et cetera, were required. What wasn't clear to me was how the existing vegetation might be impacted by flight paths, and if that was considered as part of the analysis. And in the future, is there any possibility, just given the location and orientation of the site, that those flight paths could change, thereby affecting either existing or what appears to be proposed vegetation in the site plan?
Got it. Mike Allen, can you, I didn't hear all of it, but can you address the environmental, the first item that was asked?
Yeah, so I'm Mike Allen. I'm a licensed professional engineer in North Carolina since 1997. I've been practicing in the Triangle for almost 30 years now. With regards to the landscaping, right now, we are adding some landscaping around the building. We're adding 200 plus shrubs and some more trees just to make sure that a current buffer meets the requirements. But as far as having to do anything else with flight paths, all that was considered when they located the heliport. And so there's no clearing or anything that's going to be required in order to make those adjustments for the flight paths. And I think the flight paths are also they're coordinated with RDU, so I don't see them changing in the future, but someone else will probably need to speak to that.
Yeah, so we've modeled with our operations team, both in RTP and up in Canada, various approach paths. There's dictated fairly rigidly by the FAA. We've looked at both for all types of rotorcraft, including the eVTOL. We believe we've got all scenarios covered with respect to the approach to the site without any further modification to the site. I think there are a few trees that we're doing a tree survey just to make sure all the immediate trees are healthy. But other than that, there will be no significant impact to the surrounding, the immediate surrounding area.
Thank you.
Mr. Paletta?
Question for Mr. Coleman. Could you clarify your role when you speak? Are you presenting facts as a witness, or are you presenting argument as the attorney?
I am presenting where appropriate. I'm presenting facts as evidence. Generally presenting information into evidence, which I am entitled to do in a quasi-judicial proceeding. You don't have to have, unlike say a court proceeding under 160D, you don't necessarily have to have a witness for everything. I am also, but to the extent that I have information that I'm doing, I'm really just repeating what's in the application materials. So pretty much everything I stated that where we didn't have a separate person talking to it, I was just summarizing as an advocate what has been submitted and is in the record in terms of application materials, in terms of setbacks, things like that. All that information is in the site plan and in the application materials, lighting, all that stuff.
So when you're presenting facts or evidence for facts, what's the basis of your knowledge?
As I said, we have submitted an application with supporting documentation. All of that has been entered into the record, so it is record evidence. So I am citing record evidence.
Mr. Wardell?
Yes, I just wanted to be clear. Mr. Coleman, you have not presented any fact testimony in this case. Is that correct?
I've summarized what the fact, the record, the facts that are on record, and summarize them for the edification of the board. I am not here to present any new evidence that is not otherwise already.
Right. You're not a fact witness. You just.
I'm not a fact witness.
Right. You're summarizing what's in the file for the benefit of your client.
Correct.
Okay. All right.
All right.
Sounded like his answer to the first question from the board, he was answering it as a fact witness. So that's why I wanted clarification, because it's confusing when an attorney starts getting into the area of fact, because then we have to evaluate your credibility as a fact witness, which is different from speaking as the legal advocate for your client.
I apologize for that, and so I think you were talking about the rate of departure. I think and I apologize for jumping the gun on that. I should have handed that off to Mr. Halpert. You are correct. I believe Mr. Halpert covered that, and happy to have him redo anything so you don't have to evaluate my credibility. But thank you for pointing that out. I apologize for that.
Mr. Meadows, you have something?
I got one more thing, guys, and I'm sorry I didn't raise it before. Could you talk a little bit about security? Let's say we want to go have fun as youngsters, and we go up to the helipad. Is this thing manned? Is there surveillance? How are you going to maintain security at the site?
Got it. So United Therapeutics has over 218 acres contiguous property. We have a 24/7 security operations center located at 55 TW. So within 2 minutes of this location, we have roving security throughout the campus. There are cameras located throughout the campus. The site itself is completely fenced in. So I think there'll be intrusion alerts. You know, we have, for example, we have a 4 megawatt solar field immediately adjacent to it, and we've got an intrusion alert where if anything touches the fence, it sends out an alarm. So the same technology will be used here. So I think we've got it covered. We're concerned about security for this as well as, you know, other aspects of our campus. But I appreciate the concern. We've during the planning of this, we had our in-house security team spend quite a bit of time looking at scenario A, B, C, and D. So.
All right. Any other questions for the applicant? Michael Retches.
Hi, yes. Thank you. This is really interesting stuff. Would you say that this is going to be between 1 and 10 events per day, or more than 10 events?
I would say just based on the science and research that we're doing, I think at this point we'd probably be within the 1 to 10 events. The future, once we get to a commercial product, an actual organ that FDA approves for transplant, it could increase. So I can't speculate that far out because the science, we're still developing the science and we're testing it, and hopefully there'll be more in the news in 2022 and 2023 as we get closer. But I would say initially the 1 to 10 per day should suffice. But again, as our science, as the studies continue, it could be more in the future.
And being that said, Mr. Bell, would anything like noise contours have to be contributed to more data? Being it's kind of leaning toward an airport community if you go over 10 events a day.
Well, in our case, we determined that if we had as many as 10 events per day, we would still stay below the 65 DNL contour at residences. It's really more a question of staying inside, keeping that 65 DNL contour from beyond any residential areas, so that you don't cause. But what happens once you get beyond 65 DNL is you might need to have special windows or something like that installed on the home. So it's not necessarily strictly about the number of events. It's keeping that 65 DNL contour from expanding into a residential area. So, you know, we don't want to get fixated on the number of events, but in this particular case, we've determined with the Bell 429, we could have up to 10 events per day and still stay below the 65, say within the 65 DNL at closest residences, noise sensitive areas.
Understood. Well, thank you. Appreciate it.
All right. Any other questions? Cole, would you mind stop sharing your screen for a moment? All right. Is there anyone else here to speak in favor of this application for minor special use permit? Anyone here to speak against this request? All right. Cole, do you have a recommendation for the group?
Yes, staff recommends approval with all material that the plan is all consistent with all materials submitted to the public hearing.
Thank you, Cole. All right. Any discussion? David?
A question for the other board members. I'd like to get your opinion. Sounds like a good proposal. There's a history. It's already had a helipad. It's in the right kind of district. I wondered if we should put a condition that there'll be no more than 10 events per day. Trying to anticipate if it's a wild success, which I hope it is, that if it was getting into 20 events per day and maybe the sound was becoming an issue, it could come back for some modification. So I'm leaning that way, and I'm curious what other board members might think about such a condition.
Why 10 and not 11 or 9 or 13 or 20? What is the magic number of 10?
I would say it's not. And so I think the question would be, should there be any condition about a number or not? And the reason to have a condition would be to anticipate a wildly successful program. And so I'm leaning towards some limit, 15, 20, 10. But again, I want to know what the others feel about that.
Hey, Brian, what you thinking? You're on mute, sir.
Sorry about that. Just a reminder that any condition on the use has to be agreed to by the applicant. If there is some number that the applicant feels comfortable with, then I think that's something that can be considered by the board. But the board does not have the authority to unilaterally put a condition on the use that is not specifically set forward in the Unified Development Ordinance.
Understood. And I think we ought to debate it first. Mike?
Mr. Pauletta, I certainly appreciate where I think you're coming from in this regard. I think in response, I would have a hard time in this case, kind of speculating on the success of the applicant and what might happen in the future. I think as far as the findings of fact, where I'm coming from is things I can, kind of reference in the ordinance and what whether or not this particular application meets the findings of fact. And I don't think that additional flights in this case are anything that I can validate, based on the ordinance. So I would think, I guess where I'm coming from is I don't feel comfortable, placing a condition as you suggested in this particular instance.
I have to agree. I don't know. I think if there was, something that this board has done before is that usually seems that in my 6 years that we've only put further conditions on things that have had wildly opposition show up. I don't think we've seen in this meeting today, there's no opposition to this case. I haven't heard much discussion other than a couple of questions on the issue of if there is an issue of 10 or 12 lendings or whatever that number is. I don't know if there's any guidance in the UDO either on such item. I'm inclined not to support an additional condition. Mike Richards?
Yeah, I'm satisfied with the day-night average sound levels at 65 or less. I think that's really the key point here. And I don't object to over 10.
Brian?
Yeah, with helicopter flights and drone flights, they are strictly monitored by the FAA. And so the number of flights, the height you can fly, the zones you can fly in, the kinds of drones you can have, that's all heavily regulated by the FAA. So I think it's even outside of our legal jurisdiction to put a condition that would in any way affect the ability to fly an aircraft in airspace above a certain height.
Chad?
Thank you. Thank you, Mr. Chair. Mr. Palet, I appreciate your comment. I think where you're headed is in thinking about the future and thinking about the likelihood of increased drone activity, not just at this site, but everywhere. And, do we have a noise ordinance that is going to help us address the potential concerns that one could anticipate in the future? And I am not sure that the UDO as structured recognizes a 65 DNL measurement or even has any sort of steady state DBA number that it works off of. And if I'm wrong, staff, please correct me. So I think that the regulations that we've got in place right now aren't anticipating potential impacts from widespread drone use. Having said that, I'm not sure what we would do if this applicant went to 30 flights or 50 flights or 100 flights or 1,000 flights, without standards in place that specify, not just the amount of rain or amount of noise, but the duration or number of occurrences of noise. We don't really have anything to regulate on anyway. So, I think that your comments are well taken, and I think they point to a larger concern that the city should be thinking about, not necessarily in this case, not necessarily in this year, but, we may find a future where the majority of transportation is taking place with drones, and that is going to be something that we need to grapple with. I appreciate your thought. I, like some of the other board members, not sure how we would enforce that condition except to say stop having flights. And I'm not sure that that's necessarily what we want to do either. So it is a challenge. But I mean, I believe these guys have attempted to meet the criteria. I find that they are, in an industrial area, largely, that there is an FAA study and approval that's necessary, and that it's in their interest as good neighbors to make sure that they're not creating a situation where there's disturbance, annoyance, or an unsafe condition. So in light of that, I anticipate supporting this, but I surely do appreciate, your question and your thought.
Any other comments or questions or thoughts?
Retchless. I just want to say, I live near Duke Hospital, and when I see that helicopter flying overhead, I don't think about whether the noise is disruptive, but that helicopter is probably saving a life. And with that thinking, I would be in support of this.
Anyone else? Would anyone like to offer a motion?
I will.
Natalie?
Find my I hereby make a motion that application number B220010, an application for a minor special use permit for an accessory use helipad on property located at 2 Mon Drive, has successfully met the applicable requirements of the Unified Development Ordinance and is hereby granted subject to the following conditions. The improvement shall be substantially consistent with all information submitted to the board as part of the application.
All right, we have a motion for approval by Natalie Beauchesne. Is there a second?
Meadows, second.
Meadows on the second. Amanda, we'll turn it over.
All right. Excuse me. Meadows,
Yes.
Pauletta,
Yes.
Rogers,
Yes.
Retchless,
Yes.
Major,
Yes.
Tarrant,
Yes.
Boucher.
Yes.
Motion passes 7-0.
All right, by a vote of 7-0, your request for a minor special use permit has been approved. We appreciate you all coming before the Board of Adjustment and wish you the best of luck.
Great. Thank you very much.
All right. Amanda, would you like to call the next case?
Yes. It is B2200011 County. A request for a variance from the balloon test requirement for a wireless communication facility. The subject site is located at 5193 International Drive, is zoned industrial light, IL, and in the suburban tier. This case has been advertised for the required period of time and notarized affidavits verifying the sign postings and letter mailings are on file. Seating for this case is Meadows, Pauletta, Rogers, Retchless, Major, Tarrant, and Boucher.
All right, thank you, Amanda. Would everyone who plans on giving testimony on this case, please come on. We'll need your camera on. It looks like we've got that. All right, well, Minister of the Oath, if you'll raise your right hand. Do you swear?
Mr. Chairman, this is Tom Johnson. I just wanted to clarify, it shows up as my name under Mr. Bernardo's picture, but
Okay.
that's Chris Bernardo, who's also being sworn in as a witness in the case. I just wanted to clarify that.
Thank you, Tom. Chris, you want to, thanks. You already need to top up it. All right, well, we'll do the oath real quick. If you'll raise your right hand, do you swear or affirm the testimony you'll give today is the truth and nothing but the truth? Chris? You're on mute, sir.
I do.
And Tom, I know you're an attorney, but do you plan on giving
I may get some factual information, so just to be safe.
Okay.
I do.
Okay, and do you consent to this remote meeting platform, Tom?
I do.
And Chris?
I do.
All right. We'll turn it over to Cole.
Good afternoon again. Just one moment. Good morning. It's Colbert Nigger again, representing the planning department. Planning staff request that the staff report and all materials submitted at the public hearing to be made part of the public record with any necessary corrections as noted.
So noted.
Case B 22-00011 is a request for a variance from the balloon test requirement for a wireless communication facility. The applicant is the Williams Mullen Law Firm. Case area is highlighted in red. This site is in the suburban tier, zoned light industrial within the county of Durham's jurisdiction. The existing use is industrial public surface / electrical transmission. The Williams Mullen Law Firm, agent for the property owner, submits a request for a variance from the balloon test requirement for proposed freestanding non-concealed wireless communication facility located at 5193 International Drive. The subject is zoned light industrial located within the Falls of News Jordan Lake Critical Area, FJA, Watershed Protection Overlay within the suburban tier per section 5.3.3 and 5.c of the Unified Development Ordinance. A balloon test shall be required for all proposed wireless communication facilities that require a special use permit. The proposed non-concealed freestanding wireless communication facility, commonly referred to as Unipole, will require a minor special use permit. The balloon test to be performed prior to the minor special use permit process. Thus, the applicant is requesting variance now, although neither the board nor the staff has begun reviewing a site plan for the proposed Unipole. The applicant is proposed to use photo simulations instead of balloon tests to simulate the height appearance of the WCF. The site includes an existing Duke Energy substation, and the applicant has provided evidence that conducting the balloon test at this location will not be allowed by Duke Energy, as they feel it puts the operation of the substation at risk. And staff will be available for questions throughout the hearing.
Thanks.
Looks like Chad has
Yes.
some questions.
Just one question. Thank you, Cole. I thought I read in the application, and I'm just asking for clarification here. I got the impression from reading the application that the UDO allows for alternative methods of demonstrating the appearance of the facility. In other words, there was a means to do this outside of a balloon test. Is that accurate? Are there other ways that people can meet that requirement?
So we don't have administratively determined what those other alternatives are. So at this time, the reason they're coming for the board is to get a variance that because we don't have those alternatives listed in the UDO.
Thank you.
All right, any other questions from Cole before we hear from the applicant? Hearing none. Tom, we'll turn it over. I'm assuming we'll turn it over to you.
You will, and that's fine. And thank you so much, Jacob. I'm Tom Johnson. I'm an attorney with the law firm of Williams Mullen at 301 Fayetteville Street, Suite 1700 in Durham. I've been a practicing attorney for almost 37 years and been working with assisting companies in obtaining approval of wireless tower sites sent for probably 30 of those 37 years. I'm here before you today on behalf of PeakNet, who is an entity related to Duke Energy that constructs and manages towers on Duke Energy properties. In this case, a tower is being proposed on the electrical substation site in the Trayburn development to improve wireless service in that area to obviously the businesses and residents in the area. As we went through this on the site, Duke Energy, as was mentioned, the ordinance requires a balloon test. And of course, technology over the years has changed such that you can actually provide better and more relevant representations using photo simulations rather than a balloon test, quite honestly. And in this case, it's more critical because Duke Energy is concerned about floating a balloon in such close proximity to the substation. And the concern is that the wind could blow the balloon and or the tether into the substation and interrupt service and or lead to injury. So we're proposing being able to proceed forward with photo simulations, and I'm going to give you a demonstration of what those look like in lieu of the balloon test. And we had to do this first because the balloon test obviously is required for an application for a minor special use permit for the tower. And we had to get this addressed before we could move forward with the minor special use permit, which this board will consider once we, when and if we obtain the variance and once we submit an application. If I may, I'm going to go through the presentation now. If you could go to the next slide. And these are photo simulations, and I'm trying to, want to demonstrate what we're actually talking about. This is a location of the tower, approximately just outside the substation site and some adjoining trees. Next slide. This basically is an overview of where the locations for which you'll see the photo simulations are located. So we do this whenever we do photo simulations of sites. We chose these 4 sites, and the NV means not visible, but we can do any number of sites as requested. Go to the next slide. And again, this is just another map without these having the aerial superimposed. Next slide. Okay. This is a view from location 1. Next slide. This shows the monopole tower simulated from location 1. Next slide. This again is location 2. And this is the tower at that location. And we'll often highlight them if it's hard to see by doing an arrow so you can see where the tower will be. Next slide. Again, location 3. And this is a tower from location 3. As you can't see, it's smaller and yet barely above the trees at this location. In the location 4, it's not visible, but through a representation, as you can see here, you can show where it's just below the trees. And we like to show that because oftentimes there's a question, well, how much lower is the tower than the tree line? Next slide. I think that's it. Yeah, that's all. So basically, this is our request. As part of the record already, you have the letter from Duke Energy indicating their concern. I will tell you that this matter was on, we have applied many months ago for this, almost a year ago, for this variance, and kept continuing the case because we had an adjoining landowner who was Terry Sanford Jr., which Mr. Bernardo is here to be able to speak to, but he was one of the co-developers of Trayburn. He has an adjoining property. He was concerned about visibility. We went through multiple photo simulations with him from whatever location he wanted us to do it from in order to satisfy him about how the tower would appear from various locations. And after going through those various photo simulations, many more than this one showed, we determined that we satisfied him that it would not be detrimental. Of course, that determination will be made on the special use permit application, but that's just an example of what we can do with the photo simulations. I'm available for any questions you may have. I will summarize obviously the requirements. Unnecessary hardship would result from the strict application. I mean, really, we can do as well or actually better with photo simulations than a balloon test. It's just the way the technology is. So, I mean, it's unnecessary to require the balloon test when we have a viable alternative as recognized by the ordinance, but not specified. The hardship results from conditions peculiar to the property. Again, it's an electrical substation. That's the issue here. It did not result from actions taken by the applicant or the property owner. I mean, that's not the actions and didn't require this. It's because of the requirements in the ordinance, not for any actions of the applicant. And the requested variance is consistent with the spirit, purpose, and intent of the ordinance. Again, we can show what a balloon test could show and actually do better than the balloon test with the photo simulations. I'm open to any questions. I tender Mr. Bernardo to be able to speak to any of his conversations with Mr. Sanford and the photo simulations he did, as well as conversations Mr. Bernardo's had with Duke Energy, which he can speak to if necessary. I do ask that this photo simulation presentation I just showed be included in evidence. I did not see it in the packet, so I do want it to be included in evidence in support of this variance request, and we're available for any questions you may have.
And Tom, that's actually what I was going to ask is, if you wanted this information in your testimony to be part of the record? So
absolutely.
All right. Do you want Mr. Bernardo to speak now, or do you want just to be answering questions if there are any?
I'm fine for him to answer any questions. I mean, he basically would speak to the conversations with Mr. Sanford, which I summarized. So I will just have him available for questions, or if there are any concerns or cross-examination that may need to be made of him, he's available for that.
And I'm going to assume that the neighboring property that you've been talking about was notified of this variance hearing. I'm sure he was.
Well, that's what led to the conversations, is the notification with respect to the variance hearing.
Got it.
And he still owns some fairly large tracts of undeveloped property nearby. To my knowledge, we've not had any contact from any of the industrial users in the office park so far as any questions or concerns they may have. It was just Mr. Sanford that raised had questions and concerns, and to my knowledge, and Mr. Bernardo can confirm that, we satisfied his concerns.
Got it. All right, Mr. Meadows, you have a question?
I do. Thank you, Mr. Chair. I have a couple of questions. One for Mr. Johnson, one for Mr. Bernardo, and then one more for staff. I want to ask the question of Mr. Johnson if he could talk at all about whether or not there was any further discussion with Duke about the ability to come closer to meeting the spirit of the ordinance with respect to a balloon test. I don't know if there was or is some alternate way, whether that's a boom truck or some other means to keep the balloon. I understand their concern, obviously, but I'm just wondering about if there was anything else that was explored with Duke. So, you know, that would be question one. Question two is to Mr. Bernardo, and it actually pertains to the what is on the screen right now, which is the view from location 4. I'm interested in hearing a little bit more about how tall those trees are that I'm seeing in the screen there. I think I heard that this was a 180-foot tall monopole, and my guess is that those trees are probably, you know, 80 feet, 90 feet, maybe 100 feet tall. So curious about a little bit more about that market difference in that one. My last question is to staff, which is, has the city done balloon tests for telecommunication facilities on or near, you know, electrical transmission sites in the past? So those are my 3 questions. Thank you.
And I think I can really answer all of those, but you know, again, if Mr. Bernardo needs to come in, you know, it could conceivably a crane be brought in and a balloon be floated at the top of the crane. I mean, I guess potentially, and I'll let Mr. Bernardo say if it's different. I mean, that could potentially be done, but our position was this alternative is much more accurate. I mean, you can put a balloon up there, but it really doesn't tell you what the tower will look like. The photo simulations actually tell you what the tower will look like. And kind of related to your second question is, yes, those trees may be 90 feet in height, but it's a combination of the height of the trees at this location and the distance the tower is from the trees. If you look, you know, if you recall when we went through this presentation, there were some of these that were closer to the site where the tower was bigger and more visible. As you get further from the site, the tower gets shorter in height because it's more distant. So even though this is a 180-foot tower, at this location, it's only appearing, you know, just below the tree level, say that assuming the tree level is 90 feet, solely because of distance. And if we go back to one of the other previous slides, I just want to show kind of that perspective, if you don't mind. Like here, you know, this location 3, see how small the tower is? That's simply because of distance. Go back to a couple of more slides before. Well, this is really close, so the tower appears bigger. And go back to the next location 1. And again, it's clearly above the tree line here, and that's simply because we're closer to the substation. So that's the difference. And in fact, in doing these hearings, again, over the years that I've done them, photo simulations, as you're really, really close to the site that has trees around it, the trees will cover it because you're looking up at the tower, but the trees might block your vision. Then you move a little further from the site and then the tower becomes visible. But then you get even further from the site, the tower again loses visibility because of the distance from the site. And those are the things we can do with a photo simulation that in reality, even if we rented a crane and put it up there, it really, the mass of the crane is going to be different than the mass of the tower. And it's really not going to provide anything that's any more helpful to the residents than the photo sim, are actually not as helpful to the residents or the adjoining property owners as the photo simulation. So that's where we go from there. Again, I know you had the staff question. I think that answered the first 2 questions.
One more quick follow on, if you don't mind. Is it
Absolutely.
possible for you to do a photo simulation in October or November?
We could. We would just be delaying the site to wait, because we'd have to take actual photos or look and see if we can find some online photos from that time of year. Because we'll often use Google Earth, and I think these were actually, can't recall, I think these were based on actual photographs, but sometimes we use Google Earth. So if Google Earth has a fall picture, we could do that. But otherwise, we have to wait until the fall of the year when the trees lose their leaves in order to do this. Obviously, there'll be some visibility of the lower part of the tower when the tree leaves aren't there. But that doesn't vary on the balloon test either, because if we did the balloon test in accordance with the ordinance, we would be doing it right now when leaves are on the trees. So whether the leaves are on the trees or the leaves are not on the trees doesn't impact the use of the photosims versus the balloon test.
Thank you.
Mike Tarrant.
Thank you. I just had one question regarding the simulation images. Did you, Mr. Johnson, take into account topography and elevation, or were the simulated images based purely on horizontal distance?
No, they're based on elevation as well. So any picture that's taken that we use has what elevation it was taken and the distance it was taken, and that's all factored into the photo simulation when it's done. And including the elevation at the site itself, the base elevation of the tower.
Thank you.
Sorry, David Paletta.
Quick thing, just to answer Chad's last question. Sorry about that. I didn't mean to interrupt. There was a third question that he asked staff. As far as I know, we haven't had balloon test or those on a previous electrical stations. Sorry. Go ahead.
I have several questions. My first one is, what is the relationship between PeakNet and Duke Energy Carolinas?
Chris, can you answer that?
We are a majority owned affiliate of Duke Energy Carolinas and Duke Energy LLC. Other entities.
I just didn't pick up all of your words. Could you repeat? I just couldn't hear you.
A majority owned affiliate. So they own the majority portion of our entity.
So Duke Energy owns a majority portion of PeakNet?
Correct.
That's correct.
Is in this instance, is there any written document between PeakNet and Duke Energy?
Written document in terms of a lease or something of that nature?
Yes, lease, offer to purchase, whatever.
Go ahead, Chris, you can address that.
There will be a ground lease specifically between Duke and PeakNet as we get farther into the process. It's usually something that is not undertaken until zoning is approved. We start that process at that point. But as part of that process, there are stakeholders within substation, maintenance, transmission, Duke Energy real estate that all have to review and approve the project prior to. So it's kind of a formality at the end of the process to sign the document saying this is the ground space we're taking up.
Why did PeakNet choose this property?
PeakNet actually chose this property, one, because it's actually Duke-owned property. That is our specialty, is actually utilizing Duke-owned assets to fulfill carrier needs, whether that be building a new monopole on transmission substation property or attaching to transmission lines. Again, it depends on what the carrier's requirements are. This site is centrally located in a very difficult area to cover. My hope is that once this pole goes up, I will actually get all of the carriers on it. We're designing for a 4-carrier pole, and it will provide a significant boost to coverage to the area. But that would be something we would normally present in the special use permit for the tower itself.
Why did PeakNet not place the tower farther away from the substation?
It's a matter of the gradient of the property, and the location itself was just the most agreed upon location between all of the departments within Duke and our engineering firm, essentially.
Yeah, and there's also Mr. Sanford obviously had concerns as it got closer to the property line to where his property was, which obviously gets addressed in the special use permit more than anything. But that's So if we move it closer to adjoining property owners, they get more concerned. So doing it more centrally located, we take advantage of the tree cover that's around the substation and would be around the tower without disturbing the existing trees.
So you're using Mr. Sanford's comments as part of your answer?
As part of my answer, but the biggest part of that, and I just won't use those comments. I'll just say, by putting the tower closer to the substation, we're able to allow the existing tree cover to remain to buffer the site from adjoining property owners.
You would agree all of your statements about Mr. Sanford are hearsay, so that raises other questions.
Understand that. I gave that as an example, not for proof of the matter asserted, but an example. And obviously this is quasi-judicial, not judicial. I can let Mr. Bernardo share his side of it. And obviously Mr. Sanford has an opportunity to come and weigh in on the special use permit in general. Our point is we can show as many locations as accurately, or actually more accurately than a balloon test with photo simulations. And that's what we're asking to be able to do, which the ordinance recognizes that we should be able to use alternatives.
That's my question had to do with the location of the tower. I was curious.
Right.
A question for either of you is the evidence of hardship is referenced as attachment 6, a letter from Duke Energy. It's addressed to Mr. Bernardo. It says, after a thorough review of your request to conduct an elevated balloon test in proximity to Duke Energy's 100 kV Trayburn substation, it has been determined that this activity poses a hazard to the safe operation of our system and therefore will not be permitted. That statement is a conclusion. Is there any evidence in the record as to the explanation for why it was a hazard?
Let me let Mr. Bernardo speak to that, about his conversations with Duke that led to that letter.
The conversations were actually had between substation engineering and transmission because of the transmission lines that run along the north side of the property. There is a concern that if a balloon is flown there for the period of time that it has to be flown, that it poses a significant risk to drifting into either the transmission structures or across the substation, which is a hazard that Duke Energy is not willing to permit if there is an alternative, such as the photo sims. Essentially, they won't let us fly a balloon on the property. I know you previously had said something about actually bringing a crane out and height of the crane. We would not be able to do that with the parcel itself as it stands now because of the trees. There is no way to set up a crane of that size on that parcel as it stands currently.
And the point is, it would require, like we said earlier, it would require removal of trees to do the crane, which then becomes counterproductive to what we're trying to do in using the trees as a buffer. But go ahead.
Who prepared attachment 5, the photo simulations?
It was a contractor, Mike Samper.
Do you know what that individual's qualifications are?
All I can say is he has done these photo simulations regularly and they've been accepted. I did another site in Durham in front of this board of, or not this board of adjustment, not these members, where those photo simulations were accepted as evidence in support of a special use permit.
Are these documents being presented as, scratch that. So do you know the education, training, and work experience of Mr. Samper?
I don't have that in front of me. The point here is that the photo simulations are a reasonable alternative to a balloon test. When we get to the special use permit, I'm happy to have Mr. Samper be present and testify as to his qualifications. Because the question here is, are there alternatives, a reasonable alternative that can meet the requirements of the ordinance other than a balloon test? Our point is photo simulations can do that. So point of the minor special use permit, which this board will consider, we can, have Mr. Samper available to talk about his qualifications, and the board can then weigh the accuracy of the photo sims.
Okay. So the answer to my question is we don't know what his qualifications are at this moment.
I don't have them in front of you at this moment, but again, if the variance is approved and we use photo sims, we've got the burden at the special use permit hearing, and we can have him available to speak to it. I know he has done photo simulations for multiple sites that I've done in multiple jurisdictions, and his work product.
At page 10 of the packet, it states photo simulations are included with this application that demonstrate that photo simulations are an excellent substitute for a balloon test.
Correct.
It goes on to say photo simulations create a more accurate representation of the appearance of the proposed WCF than does a balloon test. Who is making that statement? Is that you?
That is me.
Can you state your qualifications? What is your expertise in photography or anything other than that indicates you're an expert witness on this?
Okay. I've been an attorney practicing law for 37 years. I'm a certified specialist in commercial and residential real estate. I've handled tower matters for approximately 30 years and viewed many photo simulations, many balloon tests over those years. I would say hundreds, if not close to 1,000 tower sites in the state of North Carolina. Even when in jurisdictions, including Durham, where we do balloon tests, we always follow up with photo simulations because the photo simulations provide a more accurate representation of what the tower will look like. In my experience, have been involved with presenting photo simulations to boards for approval and actually gone back and looked at the sites once they're constructed after approval. And it's amazing how accurately those photo simulations represent the actual tower as built. The technology is there, that they are extremely accurate.
Each photo in the packet, it has in parentheses a number of feet. Who calculated the number of feet?
That's Mr. Samper. When he does his calculation, he determines the distance.
Is he a licensed surveyor?
That information is easily gathered from Google Earth because you have the coordinates of the tower base itself and the coordinates of the site that the photo is taken from, and you can do the calculation mathematically on that.
I'm going to interject here. David, this has been an ongoing discussion between the two of you. Can you get to the point of your questions? We've got two other people who need to speak as well, and then let Tom answer them.
This is the point of my questions.
I'm following you where you are, but it's like I'm getting chats as well about they'd like to ask questions.
I'm happy to stop and let others ask questions, and I have a few more to go.
Okay. No, I want you to continue. This is your time.
No, I have a fair number, and I'm happy to let other board members ask their questions, and they might ask the questions I have in mind. But and I'll come back if.
Well, I don't know.
But I do want to make the point. These questions about accuracy, distance, these kind of questions that, and I appreciate what Mr. Paletta is saying, but all of that would be relevant to the minor special use permit hearing and really where that discussion is occurring. We're just asking here as to whether or not we can use photo simulations in lieu of doing a balloon test where the location and the risk to the Duke Energy site is too great to be able to do the balloon test. You will have another opportunity, this board will, to consider the minor special use permit. And if you don't believe in the accuracy of the photo simulations, just as you could question the accuracy of the balloon test, I think that's more relevant for the minor special use permit. My point is, and as was mentioned earlier, reasonable alternatives are allowed under the ordinance, and we're just asking for that reasonable alternative. As far as carrying our burden of proof, we can do that at the minor special use permit process would be my position, and that's what I'm requesting.
Chad, go ahead. I'll come back or anyone else, go ahead. I'll come back.
I guess, Brian, as county attorney, sorry, Brian, you're on mute again.
Sorry about that. Hey, Tom, we dealt with each other on one of these other telecommunication pole issues. I just wanted to suggest that one of the issues that the board has to resolve is in providing one of these alternatives, that there's an accuracy in the alternative that could be acceptable as an alternative.
Right.
And so I understand that you're saying that that's more relevant for the use permit, but I will say that I think it's also relevant for the variance. And is it at all possible for you to present the person who actually did the simulation to the board so that they can explain how they did it and why it's accurate? Is that a possibility for you to either get that person online or present that person to the board in some form or fashion, even if you have them on the phone?
Yeah, and I don't know that I could get him on the phone right now, but I can present him if that's a concern and the board wants to hear from him. I'm absolutely fine to do that, Brian. If that's necessary. The only thing I can speak to in my experience is I worked in probably substantial number of jurisdictions in the state on these issues, and there are very few that still require balloon tests. We're able to do photo simulations in lieu of a balloon test. So I'll just make that point. But again, if it's a problem for the board members that Mr. Sampair is not here, I can get him here and have him available to talk about it.
Right.
I'm perfectly willing.
Right. I agree with you that the simulations generally are very good substitutes for balloon tests. The only problem is you can't testify to that because you're not a fact witness. And so I think it's going to be a problem. And if you could just have Mr. I forgot his name.
Sampair, Mike Sampair.
Mr. Sampair show up, or even get on the Zoom call or a phone call. I think that'll go a long way to achieving a comfort level from what I'm hearing from members of the board.
And to showing up to this meeting in response to that, since he hasn't registered prior, we would have to open the list and register him. So we would need his information if he was to attend this call, unless there's some other way to correspond with him in another way.
Right. And Brian, one thing, I guess, and that was a question in some of the prior hearings before the board today, with the question whether the lawyer was a fact witness versus appearing as an attorney. As a fact, I can't appear in kind of 2 points as a fact witness and as an attorney advocating. I mean, and a fact witness would be based on my experience. I can have Mr. Bernardo speak to his experience because he's done a number of these sites as well. But again, if the board is not comfortable that that's enough, we can continue this and get Mr. Samper at the next meeting.
Which is at the board's discretion, I guess. Chad?
Thank you. I support the notion of testimony from the person who prepared the photo simulations. I would also be interested in understanding a little bit more about how the applicant's notification of adjacent owners with respect to the photo simulations reaches the same level as section 533 whatever in the UDO. The balloon test requires a mailed notice. It requires a posting. The balloon is in place for several hours. Affected parties can actually physically drive by and reach their own conclusions about, can I see it? Can I not see it? Is it going to be an issue or not? I'm not suggesting that a photo sim can't do that. I'm wanting the applicant to explain how the photo simulations provide that same level of experience that the balloon test does. If in fact the decision is made to come back before this board. Thank you.
And I would just make the point, we're fine to notify whoever would need to be notified for the balloon test. And if they request a simulation from their property, do that. But the balloons, it's a small balloon on a string. It doesn't present nearly the mass or the accuracy of what the tower itself will look like. In fact, you could easily have somebody on the other side of that same question say, well, how does this balloon that you're floating in the air, much like a balloon at an automobile dealership or something like that, tell me what the tower will actually look like? I've had folks say that. So, that's the difference. As I said earlier, typically we're going to float the balloon and do the photo simulations because the photo simulations are more accurate. That would be my only response to that. I understand about the drive-by, but I think we can meet the intent of the ordinance by giving the notification and the opportunity if somebody requests for us to come and do a photo simulation from points on their property where they may be concerned.
All right. David, do you have any, would you like to continue?
Another question I had about the photo simulations was, I was curious what was the elevation of each photo. I did not see elevation. Did I miss it?
The elevation was not listed on there, but I mean, I can certainly, as I said, I can get Mr. Samper to list the elevation. What he does is the elevation from where they're taken and where the base of the tower is. And that's what's used to generate the photo simulations. Certainly I can have him generate a set of simulations that lists the elevation of the site and the elevation of where the photo was taken.
Those are all of my questions.
All right.
And at this point, Mr. Chair, if there's enough concern that I need to have Mr. Samper here, I would just ask it be continued and we'll bring Mr. Samper. I mean, I'll leave that to the board so far as my request for a continuance.
Yeah, I have no issue moving forward, but it sounds like we do have from a few. So is anyone else, any of the other board members who haven't spoken, have any thoughts on this? Hey, Mike.
Yeah, I had a question earlier about the method in which you determine a picture can show the tower at the elevation. I know it's probably a mathematical, but I just want to hear, being a layman's term, how you determine that tower is going to be elevated to that height from 773 feet away. I just don't know enough. I'm not a mathematician, but I'd just like to hear that explanation. That's all.
again, they do it, it's done based upon coordinates, elevation, and height of the tower. And there's a mathematical computation you can do to, especially in these simulation programs, that can do that mathematical computation to see what it would look like. Personally, I don't know the computation because I depend upon the photo simulation experts to do that computation, but that's what is used.
All right. Anyone else? Thoughts on this? Hey, Mike.
I would just add, Mr. Chair, I agree with you. I would be fine moving forward with this. I have experience myself with preparing similar type images, so I know how they're prepared, and I don't think there would be any value to me to bringing the person to the table to explain how this is prepared. But certainly, if other members of the board feel the need to do so, I would support that.
David?
He's on mute.
You're still on mute, sir.
Are we entering deliberation, or are we still with questions?
I'm wanting to hear from board members to get consensus on whether they want to hear more from this other individual, or should this case move forward. Hey, Natalie.
Yeah, I have a question. Just to clarify, Mr. Johnson, so are you saying that the trend now is to use photo simulations versus balloon tests? Is that how the majority of people are doing it these days?
Yes, and even when balloon tests are done, photo simulations are done at the same time. So there are very few jurisdictions that still require balloon tests.
Okay, and just out of curiosity, how large are the balloons?
They are, it's under your ordinance is what they have to be at least. Okay. I can pull that up real quick.
That's okay. That's okay. I was just curious because I've never seen the balloon test done. So I was just curious.
I mean, it's typically a round balloon. Some will use a blimp-shaped balloon in order to try to accommodate for winds. They're typically, I think, about 10 feet, but I can look that up.
That's fine. That's fine. I was just curious. Thank you.
Mm-hmm.
Jessica? Major?
So I don't have any concerns about what Attorney Johnson is saying, but I do think that we have to have it from a competent witness. I do have concerns about, I don't want to say it this way, but potentially cutting corners in this case and then cutting corners in other cases. So I hate to have to ask them to come back with that witness, but my preference is going to be to have that gentleman come in.
Brian?
This is just a reminder that in county cases on variances, you got a 4/5 majority requirement. So you would have to have 6 of the 7 board members that would agree in favor of the variance. So I just wanted to remind both the applicant and the board of what that requirement was in the county, because it's different from the city.
I'm glad you did that. David?
It may be useful for the applicant and for the board to go ahead and proceed to our standard deliberations. And that which would include, if the board wishes to request an additional witness, there's some other factors that may come out in deliberations that affect what the board wants to do. But I'm kind of waiting till we formally proceed.
Yeah, we have 2 options, but Tom, we'll hear from you, then we'll go into deliberations, and I'll announce those 2 options.
Yeah. I did want to clarify the size of the balloon. It has to be at least 3 feet in diameter and it has to be red or orange.
Thank you.
All right. Now we're in deliberations. All right, there are two options. The applicant seems to be okay with coming back to next month's meeting. But does anybody want to offer any more thoughts?
I do.
I'm sorry, David.
Going to finding number 1, is there an unnecessary hardship? The applicant is the majority owner, well, let me be very precise. PeakNet LLC is owned by Duke Energy, or Duke Energy is the major ownership of PeakNet. Clearly, Duke Energy, the owner, does not have a hardship. They don't have a problem. It raises the question: can an entity owned by the owner have a hardship separate from that entity? Based on what I've heard, I don't think the applicant has met its burden of proof of showing a hardship. Those are my thoughts on finding number 1.
Just as a quick thing, the meeting for May is already locked in full. So they would not be able to go to the May meeting. They would have to proceed to the June meeting. Just as a information. So if you do continue, it would make sure you specify that it would be at the June meeting, not the May one.
I have a problem with that, and I think that that's wrong. Not wrong, that may be the case, but I don't think that I don't like that. But anyone else? Does someone else have a thought on this? Or Dave? Or hey, Chad.
Hi. I would like to agree with Jessica that for the sake of consistency, I'd like to hear from the person who is supposed to be the expert on this. I don't think I heard that the applicant has a problem with that necessarily. And I would be interested in hearing from the person with those skills. The UDO is quite clear about the balloon test. It does say there are other methods. It doesn't elucidate what those are. Certainly the fact that we're hearing a variance means that the staff's opinion is that this alternative isn't sufficient. So I'd like to hear from the person who's putting that together, and encourage the staff to explore whether or not, if in fact these things are acceptable, if in fact we are behind the times with respect to requiring balloon tests, and that photo simulations are the way to do this, that we adjust the UDO to reflect that. But that's not where we are today. And I also think it would be great for the applicant to talk about the opportunity for notice. I think they mentioned that they're happy to prepare these for anyone who asks, which I think is perfect and fantastic and above and beyond the call. As long as people are aware that they're willing to do that, I think it's great. So that's where I'm coming from. Thank you.
Tom, what are your thoughts about continuing this to the June 28th meeting?
I did want to make that, and I'm fine with that, because obviously there are enough concerns, and I know the 4/5 requirement that we need to meet. I do want to make 2 points. One, that PeakNet may be a majority owned. It's a separate entity. It's a separate person. So, that's enough separation in order to create the hardship. Duke's not going to build the pole. PeakNet's going to build the pole. So, that would be my first point. The second is, I want Cole to clarify, but I don't think he was saying that staff had a problem with the photo simulation as an alternative. I think the staff's problem was there was no listing of what an alternative is. So that's why we're here on the variance, as I understood it. I want to clarify that, but I don't think the staff had any problem with the photo sim. I just think they felt like they didn't have the authority to agree that it was an alternative method.
Good point. Cole, I want to clarify that.
Yeah, absolutely. That's correct. And what Thomas Johnson's saying, we don't necessarily have a problem with it. We just don't have, I guess, really the expertise to administratively approve something that we're not an expert on. So that's why we do ask for the variance, just so it's on record and the expert testimony is provided that they determine as an alternative.
All right. Thank you for that. All right. Does anyone want to make a motion that we continue this case to June 28th?
Meadows, I hereby make a motion that this case B220011 be continued to a date certain, June 28th.
Is there a second?
O'Shane, second.
Natalie O'Shane on the second, and Amanda.
All
take it.
right. All right. Meadows,
Yes.
Pauletta,
Yes.
Rogers,
No.
Retchless,
Yes.
Major,
Yes.
Tarrant.
Yes.
All right. Bouchane.
Yes.
Motion passes.
Oh, may I?
6 to-
Am I allowed to change my vote?
Yeah, I believe so. I'm not sure. Okay, you're changing yours to no?
I would like to change to a no.
Okay.
Thank you.
Motion passes 5-2.
All right. By a 5-2 vote, we'll continue this to our June 28th meeting.
Brian, are you gonna jump in on this?
No, there's nothing to jump in on. It's just a majority vote for the continuance.
Okay, just making sure.
That's right.
All right, so it's continued until a date certain of June 28th, with the provision that the applicant have the expert on the simulation that they would like to submit in the alternative of the balloon test.
Yeah, that's correct.
Shouldn't take very long.
No, I'm assuming that this will be a 10-minute discussion next time. All right. Well, I've got some folks that are interested in taking a break, I believe, right? Jessica, you got some?
Yes. I certainly understand that that's an inconvenience for Mr. Johnson. Can we put them on the calendar first? Since it's going to be so short.
That's a good point. Jessica, maybe we can put him at the top of the agenda in June.
Sure, we can do that.
Thank you. All right, a break. How long do you guys want? I know we've got 2 more cases. 10 minutes, 15, 5, 10.
At least 10.
10 minutes for me.
At least 10, please
Okay.
God. All right, it's 10:32. Let's come back at 11:30. Oh, excuse me, it's 12:35. Let's come back at 12:40. 12:45. Sorry, guys.
As we return, the two participants for case B 22-000-112, I see Alicia Barnes and Arthur Barnes. Can you please accept the request to be promoted to panelist? Thank you.
All right. I know we're still waiting on the applicants for the next case to be promoted, along with Josh Mitchell. But Amanda, would you like to call the case and clarify the scene?
Yes. B22-00012, City. A request for a variance from the street yard setback standards. The subject site is located at 1908 Southgate Street. Is zoned residential urban 52 RU-52 and in the urban tier. This case has been advertised for the required period of time and notarized affidavits verifying the sign postings and letter mailings are on file. Seating for this case is Meadows, Pauletta, Rogers, Retchless, Major, Tarrant, and Bouchane.
All right. Would anyone who plans on giving testimony for this case, please turn on your cameras and we will administer the oath. I'm only seeing one. I think we've got three. Chris?
I might have made a mistake. Alicia and Arthur Barnes did not say they indicated that they wish to speak.
Okay.
Josh, is that correct? All right.
Okay.
It'll be just Mr. Mitchell.
All right. Mr. Mitchell, if you'll please raise your right hand. Do you swear or affirm the testimony you'll give today is the truth and nothing but the truth?
I do.
And do you consent to this remote meeting platform?
I do.
All right. Thank you. And Cole, I guess we'll turn it over to you.
All right. Good afternoon. Cole Reniger representing the Planning Department again. Planning staff requests the staff report and all materials submitted at the public hearing to be made part of the public record with any necessary corrections as noted.
Noted. Thank you, sir.
Case B 22-00012 is a request for a variance from the street yard setback. The applicant is Joshua Mitchell. The case area is highlighted in red. The site is in the urban tier, zoned RU52, and is in the city of Durham's jurisdiction. The existing use is single family, but this is for a proposed single family. Joshua Mitchell, applicant, requests a variance from the street yard setbacks for a proposed single family dwelling. The plot plan included with the building permit application submitted to the city shows that the house will be outside the 20-foot required street yard, but a current foundation survey shows that the foundation is 1.5 feet within the setback. Due to a surveyor error, this house was built within the setback and not in line with the plot plan reviewed by the city. The property is on residential urban RU52 and in the urban development tier. Unified Development Ordinance section 7.1.2b requires that the street yard in RU52 zone districts shall be 20 feet for single family housing. The applicant is requesting a 10% reduction from the street yard to allow 18-foot street yard. Chad, I see you have a question.
I do, Cole. Thank you. I see two surveys in the packet. One looks like it's dated 5/20/21 and shows 20 feet between the front lot line and the edge of the structure. The other one, which is earlier, is dated 2/3/22 or 1/31/22. Oh, okay, I see. So the latter one is we're subbing out the original survey for the new survey with the date where it says measured 1/31/22. Excellent. One last question. Is the building built now? Has it been completed?
I believe not. I'll let Josh speak to that, but I believe that the bank wouldn't give the loan because the foundation survey showed it to be within the setback.
Thank you.
All right, any other questions for Cole before we hear from the applicant? All right, Mr. Mitchell, we'll turn it over to you.
Good afternoon. I'd like to thank Chairman Rogers and all the members of the board for their time and service to our community here in Durham. My name is Joshua Mitchell, and I work for Boundary Zone, which is a land surveying company in the Durham and Raleigh area. My wife and I have lived in Durham now for about 2 years, and I'm happy to be presenting to you today. I'm representing the builder, who is also the property owner. That's Art and Alicia Barnes, and they are not able to make it to the call today, or to the meeting. And I'm also representing my company this afternoon as we request a 10% reduction of the street yard setback for the property located at 1908 Southgate Street in Durham, North Carolina, as depicted in the Unified Development Ordinance, Section 7.1.2b, as Cole pointed out. If granted, this variance request would designate the street yard setback as 18 feet instead of the typical 20 feet. I wanted to start off by apologizing, though, for not having my presentation submitted by the materials deadline. I'm typically not one to make excuses, but I was out of the country on vacation when the registration email came in, and since then I've had ankle surgery. So if you will allow me, Chairman Rogers, I do have a brief PowerPoint presentation to present for this case, but if not, I'm more than happy to make my case verbally.
All right, now tell us again what you have that you'd like to, and what you submitted.
Well, it's just a presentation. Some of the slides on the presentation are similar to what you see in the staff report that Cole just reviewed that you can see on the screen. Some of them are similar there, and there's just a little bit more detail and explanation on the PowerPoint presentation.
All right, Cole, do you have that presentation?
I emailed the presentation to Cole and to Chris earlier this morning, but I also have it available here if you would like me to share my screen. But
usually, I think the screen sharing just stays with the planning staff. It's kind of one of the.
Yeah, I'm gonna let Chris present. He's offered to, so I'm gonna let him present from his screen.
All right. So I do have a question. If there are. Is there any known opposition or anybody opposing this case attending today?
We don't have any opposition that has registered. So.
All right. Yeah. Oh, what was that? Okay.
There's no. Yeah. Did you hear me? Yeah.
Yes, I did. All right. Well, yeah, I think usually we're pretty strict about this. Certainly over the 2 years, I don't even know of a time, maybe once, that we've allowed this, but I think we'll allow it this one time. Chris, do you have it? Go ahead.
All righty, thank you so much. I appreciate that. So if you could go ahead to the second slide, Chris. So from an analytical perspective, we really just want to present all of the board members with the necessary and pertinent information so that you can understand a little bit better what happened in our situation here. Next slide. So again, this was just seen on the staff report that everyone saw. This is an image showing the original home at 1908 Southgate Street prior to July 2016. So that the house that's shown on there is the original house. What we've done is we essentially just drew a line along that front property line and pulled it back so it's touching the front of the house at 1908 Southgate. And as you can see, all the houses on the right-hand side of the subject property are currently set behind the original house. And over on the right-hand side, it says the current home at 1908 Southgate Street is, the original home is approximately 12 feet from the front property line. As was said earlier, the foundation survey, and to answer your question, the house is already constructed and built. So the foundation survey that we did shows the current home, the new home, sitting at about 18.5 feet from the front property line. And then we also surveyed some of the adjoining houses. For the neighbor to the right, 2000 Southgate Street, their house is 15.75 feet from the front property line. The home at 2010 down at the corner, that one is located 19.08 feet from the front property line. And then just for a little bit more context, across the street from the subject property, 1909 Southgate Street, that house is approximately 17.25 feet from the front property line. So based on these numbers, you can see that the current new home that has been constructed is farther away from the front property line than most of them, whereas the original was only 12 feet. Next slide, please. And again, the image above, that shows the location of the original house prior to it being demolished. And then the image on the right, the aerial, shows the location of the current house. And if you kind of compare those two side by side, you can see that the current new house sits more or less about where the old house was. But based on our measurements, we're actually farther back than where the original house was located. Next slide. This image here, this is a street view. This is a Google Street View image of the original house before it was demolished. And the next slide. So this is another street view image as well. Now, if you look at the chain link fence there, that's the right-hand property line. By utilizing this photo, we can roughly determine the location of the original home prior to it being demolished. So you'll see the fence on the right property line. It was determined to be about 4 feet tall based upon other fences in the area. And the average distance between the chain link fence posts was about 6 feet. If you extend the line of the front porch, which is shown in red there, you can see that the front porch aligns with the third pole of the fence, which can be calculated to about 12 feet from the right front property corner pin, based upon that 6-foot dimension between the poles. And just for reference, at the right there at the front corner of the property where the white picket fence and the chain link fence meet, that's where the front property corner is. It's right there behind the sidewalk. I've been on this site myself. And then the main body of the home aligns with the fourth pole of the fence line, which you can see there in yellow. That is calculated to be at about 18 feet from the front right property corner. So based on these calculations, we can determine that the main body of the home was located at the fourth fence pole. And you can also see that there's that portion of the fence that fell down, that connected to the house corner right there as well. Next slide, please. So just kind of to review a little bit, the original plot plan or site plan was completed on May 24th of last year. We did receive comments from the city of Durham and they were corrected. The plot plan depicts the location of the proposed house as was discussed by Cole. It was originally planned at 20.2 feet from the front property line, which puts it behind that front street yard setback. The builder submitted the plot plan along with the permit application on August 19th last year. Building permit was issued September 2nd. And then we staked the house in the field on September 16th to begin construction. A form board check was not ordered or prepared by the builder. This action would have found the error, and that could have been corrected at the time due to unforeseen actions. This never occurred though. And then as we discussed, the foundation survey was prepared on February 3rd of this year, which it was actually about 5 months after we started the construction staking. At this time, the front yard street setback was discovered, the encroachment was discovered, and we immediately brought it to the attention of the owner, the builder, and city officials. Next slide, please. Again, this is that same plot plan survey. You can see the 20-foot building setback line there on the front. the house was planned based on the dimension at 20.2 feet, which would be behind the setback. Next slide. And again, the foundation survey after the house was constructed. The house is fully built right now. And it shows, you can see 18.5 feet from the house corner to the front property line, which means it's encroaching by 1.5 feet. And this is why we're requesting the 10% variance. Next slide, please. Visually, in this instance, located on this property, the street yard setback is 20 feet, but we're encroaching by 1.5 feet at 18.5. However, there's no discernible difference between the front left corner of the home and the front right corner. The front right corner actually sits right on the 20-foot setback line, and the front left corner is the one that's encroaching by 1.5 feet. If you were to go out to this property, as you travel along Southgate Street in either direction, the homes located on the properties nearby, they're all visually consistent with each other in their placement relative to the street. Again, this is it's difficult to discern this visually if you are actually out there. Noticing the front left corner of this home being 1.5 feet further forward is hard to visually detect due to other homes being located closer to the street. So the other houses are, some of them are closer, some of them are a little bit farther. Visually, the home location is consistent with the current streetscape and in keeping with the aesthetics of the community as a whole. This home currently sits further back on the site than the existing homes along Southgate Street and farther back than the original house that was located on this property. Next slide, please. And here's another, this is a recent image that we took March 11th. This is the new house that's sitting on the property as we speak. That yellow line on the left-hand side is the encroaching corner. It's 1.5 feet into the setback. And then the green line of the house, that corner is right at the 20-foot setback. So it's just the one corner that's encroaching. The home was slightly rotated during construction, and that's what caused the encroachment there. Next slide, please. Sometimes we get caught up in thinking that companies are just kind of inanimate objects ran by faceless people, but I can assure you I've been working with the people at APOL Building, and them and us here at Boundary Zone. We're proudly represented by individuals that live within the communities in which we work. Like I said, I live in Durham myself. We can all agree that we're human and mistakes can occur. Those at APOL Building and us at Boundary Zone do understand the value of our community, and we strive for excellence. Unfortunately, in this instance, we missed the mark and fell short of your expectations. We hope and pray that the board understands that we'll do our best to be better members of the community. Next slide, please. Just to give you a little bit more context, this is APOL Building. At the bottom left, that's Alicia. She's the manager. And then in the picture on the right, the man in the red shirt, that is Arthur. He's the one that we do most of our contact through, and that's some office staff and some of his field workers. Next slide. And then this is Boundary Zone. That's our office staff up at the top right. And then of course, that's me and my wife down at the bottom left. And one more slide, please. So just to kind of summarize, we're just requesting a 10% reduction to the 20-foot street yard setback to allow for this encroachment of the front left portion of the house. A portion of the house was accidentally built into the street yard setback by 1.5 feet. Our intent was never malicious. The home was always planned to be constructed where we wanted it, as depicted on the plot plan. We're all human and make mistakes. This error was not malicious. It was never the intent of the owner, the builder, or Boundary Zone to build the home in a location that was not shown on the provided plot plan. And just so you are aware, multiple changes in our staking protocol at Boundary Zone have been implemented to help reduce the risk of this in the future. We've also advised the building and property owner that if there are to be any future construction stakings ordered from Boundary Zone, that there will be a form check to ensure the proposed foundation is located as per plan before any concrete is poured and before any framing takes place. This simple measure will ensure that the home is placed in the proper location relative to the front, side, and rear setbacks, and this additional step will help minimize human errors in the future. For granting this variance, hardships will be kept to a minimum for all of the individuals involved, and this variance will not adversely affect the intent of the UDO, section 7.1.2b, relative to the street yard setback. By the board granting a variance for this lot in this specific situation, The acceptance will not endanger the health, safety, and welfare of the community. It will not adversely affect the community as a whole. And the improvements are substantially consistent with the plans, or they will be, and with all the information that was submitted to the board as part of our application. We look forward to continuing our relationship with the city of Durham, to continue to work on improving our standing. And we just pray that you will grant us our request so that we can continue to move forward and construct a new home for the newest member of the Durham community. We hope that the board understands we'll do our best to be better members of our community. And again, we thank you for your service.
All right. Yeah. Chad, you got a question?
I do, Mr. Chair, and I'm sorry. It's actually a question for staff, and I'm sorry that I spaced it when Cole was talking. My apologies. Can I ask it now, or do you want me to wait? Now?
Yes. Yeah, I think now is appropriate. Yeah, sure.
All right. Sorry. Thank you. Cole, forgive my ignorance. Why don't the infill standards apply to this site?
I don't think it has enough qualifying lots to for the infill lot standards to apply on that block face.
Thank you.
Welcome.
All right. Any questions for the applicant? Mike Tarrant.
Good morning, Mr. Mitchell. I appreciate the thorough presentation. So could you just clarify the timeline again for me, please? So if I heard you correctly, before the footing, they did the foundation and construction started, and then 8 to 9 months later, you issued the foundation survey. Is that correct?
Yeah, that's correct. And this typically before either the foundation is poured or before any framing starts or any other construction, we're typically, that's what we do with all of our clients. We request that they schedule a foundation survey before anything else is done so that we can come verify that it's in the right spot before it gets built. But in this case, in this circumstance, that didn't happen.
So the house was almost complete before the foundation survey was?
Yes, that's correct.
Thank you.
Mr. Meadows?
Forgot to put my hand down. My apologies.
No worries. Mike Retchless?
Oh, sorry. I think you're muted, Mr. Retchless.
Yeah.
Sorry about that. Mr. Tarrant may have covered it, but Mr. Mitchell, what in the CAD, you said there was a miscalculation of the CAD drawings. Can you expand on that?
Yes, absolutely. So when we initially did our initial property survey, the house from July, from that photo, the original house was already demolished. So we couldn't verify its location exactly. It was estimated to be at 12 feet. But when we initially do the property survey, we locate all the improvements, roads, sidewalk, utilities, fences, and the property corners, obviously. And when we bring that into AutoCAD, into our drawing program, what we do is once everything is processed, we take the drawing and all of the points and all the coordinates and we rotate it. If we use GPS and we have GPS coordinates in the area, then we'll translate all of the points, rotate them and elevate them to state plane coordinates. If we didn't GPS, which is the case here, what we'll do is we'll take the most recent record map. And we will rotate our drawing to match so that one of the property lines matches exactly the bearing of the record map. And that'll be our basis of bearing. And you'll see that I'm pretty sure you see that on all record maps, all surveys. But we rotate all of our points. And then once you rotate the points, what that does in CAD is it changes their coordinates a little bit. And this, like I said, this was a mistake on Boundary Zone's part, but when the points were rotated, the coordinate file that contains all the coordinates for each of the points did not get updated. So all of the line work and all the points show they were in one spot on CAD, but they were actually shifted a little bit. Their actual coordinate location was shifted a little bit, which is why the house is rotated a little bit and skewed and why it's encroaching into the front setback.
Thanks for that explanation. I appreciate it.
Yes, sir.
David Valletta?
Could you repeat what you just said? I think I understood it. Could you just go over it one more time? I'm trying to understand how the mistake occurred.
Yeah, absolutely. So when we're using our survey equipment out in the field, we have our rod with our data collector. If we set our rod on a property corner, we take what we call a shot or a measurement at that location, and it gives us a northing, an easting, and an elevation for that specific spot. So that's what I mean when I say coordinates. That's what I mean. We have a coordinates for everything all the way around the property. We take measurements all the way around. After we did the initial property survey, we processed all of this coordinate data in AutoCAD on the computer. And what we always do with every survey we do is we rotate all of our information, all of our points, our line work, our coordinate data and everything, we rotate it so that it matches one of the bearings on the record map. And if you go on to Durham GIS, you can pull deeds and plats, record maps of all of different properties. And so we take the most recent survey that was recorded, whether it was a year ago or 20 years ago, and we'll rotate all of our information to match one of those bearings. So we did that. We took our survey, it's a rectangular lot, kind of like that. We rotated it so that one of the bearings on the property lines matches the record map. What the rotation does is if I have a point here and I rotate it over to here, it's going to change the coordinates of that point. So let's just randomly say this property corner is at northing 5,000 feet and easting 5,000 feet. If I rotate it, it's going to change those coordinates to, I don't know, 4,950 and 4,980 or something. But if you don't update the coordinate file in the AutoCAD program, it's going to retain the original coordinates. So it'll look like it shifted, but it's actually supposed to be back here. And so that's what happened.
At what point in the standard process do you do that check?
That happens right after we do the initial property survey. We bring all the information into the office, into AutoCAD. And once it's processed, then we do that. And we rotate it, and then we check those coordinates and we update those coordinates. And so from then on, when we do the site plan, when we do when we do the foundation survey or any other construction staking after that, everything is based on those point coordinates.
And if a foundation survey had been done when it was poured, then you would have caught the discrepancy at that time?
Yes, sir. If a foundation survey was scheduled before pouring the foundation or after pouring the foundation and before framing, then we would have caught it and we would have been able to fix it sooner. But like I said, the builder just didn't order the foundation survey in time.
Is it common for the property owner to not order the foundation survey, or does it happen all the time, or is that kind of unusual? Or
it's rare. We have our proposals that we send out to all of our clients, new or existing, and there's an order of operations. When we're doing construction on a new house, we do a site plan, we do construction staking. So we put nails in the ground for footings, for when they go to dig the footings around the house. Then once those are poured, then we stake it again for them to put their masonry or the foundation. And then once that's built, we do a foundation survey. And then once the foundation survey is done, once the construction is done, we come back to do a final as-built survey. So we have 4, if not 5 checks all the way throughout the construction process that we do with all of our clients. And like I said, it happens with every single one of our clients on time as scheduled, but in this case, it was missed and it slipped through the builder's schedule.
Oh, and the builder didn't ask you to do it.
Right. Yeah. He didn't ask us to do it until after the construction was complete.
Okay. And since the builder's not here, I'm going to ask you. So I didn't realize the house was built till now. When I looked at the drawings, on page 16, I read those to say that there was going to be a porch constructed on top of that portion of the foundation that encroaches. But they flipped the house, so is that why there's no porch there?
No, there actually is a porch, and sometimes the construction plans can be difficult to read. I'm not sure if that's where the confusion is, but if you look at page 16 at the very bottom left corner of the house where it says study, that front bottom left corner is the corner that's encroaching. And then to the right of the study, you can see where it says porch. The porch is set back in from the front, that front building wall a little bit. Let me know if I'm going too fast. But
so I'm on page 16. It looks to me like the porch is encroaching, not the bedroom.
oh, I'm sorry. You're looking at the back of the house. Bedroom 1 is at the rear of the house. So when you're looking at the foundation survey, this house is rotated 180 degrees.
Thank you.
All right. So yeah, the study in the front and the porch at the bottom of that sheet are the front of the house.
Question for Cole, or how? I thought a foundation survey was required. Why did the town not require one?
So we don't require one. We require a survey when the house being built. But we approved what was submitted to us originally. And then when it was discovered that that survey was incorrect, that's when they notified us that the survey they had submitted to the city approved was correct. So we approved what seemed to be a survey that was correct. And it met all our standards, but in actuality, that, like they said, there was an error in the file that was submitted. So we approve what was submitted, which was not the correct measurements.
So just to speak to that real quick, the plot plan or the site plan that was submitted shows the house at 20.2 feet from the front property line. That is correct. That's where we planned the house to be. That was approved, and that's 100% correct. But like I said, with that coordinate error, the house did rotate and it was built. So the plot plan is correct, but the foundation plan shows where the encroachment was.
Right. So we don't require a foundation survey. And like what he said, what was submitted to us was approved because it met all our standards. Mm-hmm. But due to the shift in the, in the coordinates, that what was actually out there was not. It was encroaching, not encroaching, which is what we approved.
Having built a shed not long ago, the building inspector required I have the survey showing the number. So I'm wondering, did the town drop the ball? You don't think such?
No, because the town approved what it was submitted based on what they shown. Okay. And so we approved it correctly. What made the issue was that after the CAD file had been corrupted or shifted, it caused that survey to no longer be correct. But it's not like they intended to place the house within the setback to the get-go. It's just because of that coordinate change, it got placed there by error. So.
Yeah, I think it's clear that this is, or it's clear to me that this is, we're talking just a 1.5 feet, not 10 feet or so. I think it's clear to me that it's just an innocent error. Any other questions? I'm sorry, I want to make sure we get ask questions, or if we have any questions of the applicant, want to make sure that we get those out. Anybody else? All right. Is there anyone here to speak in favor of this application for a variance? Anyone else here to speak in favor? Is there anyone here to speak against, in opposition to this request for variance? Seeing and hearing none. We'll bring it back to the table for some discussion. Any thoughts?
I always thought that the local government would send somebody out to do a foundation inspection and they would pull a tape and see if the foundation was inside the setback or not. So but I don't know how Durham does its thing. So, you know, if that, I think had that happened in this instance, maybe the error would have been caught before the house got finished. I don't know. I am still struggling to understand why this doesn't meet with the infill standards, and I'm sure there's a very good reason. I just don't understand it. And finally, you know, like you, Jacob, I think, you know, this is somewhat de minimis. There are quite a few homes on the street today who appear to have setbacks that seem to be less than 20 feet. I do not know that for sure. I didn't pull the tape. I don't know. But in looking at aerial photography, you know, I don't believe that this house in the location that it was constructed in, you know, presents a serious affront to harmony along that street front. I don't think that that's it doesn't jump out at me as being particularly obvious. And so, you know, the house is built. I don't know that we would necessarily make them tear the entire house down. I'm not sure that that's a practical response, in my personal opinion. I wonder, again, why a foundation inspection wasn't completed by the city, and I'm sure there's a good reason. But you know, I feel like, you know, that would be a way to stop this kind of thing from happening. Fortunately, we don't have too many of these, but you know, this isn't the first one. I'm inclined to support it because the house is there, because it's not necessarily a major change to the character that exists along the street. And I appreciate the chance to share my thoughts.
Chad, this is Jessica Dockery from Planning. Let me respond to Chad. I think that there was a call for a foundation inspection, but it was too late in the process. It was already under construction. You have to call when you're done to have somebody come out to do that, and that step was skipped.
Okay.
So when they finally called and said, come out and inspect, the house was built.
Gotcha. So there is a requirement for an inspection to be completed by the city. It's just that the applicant failed to do that.
Correct. And that's where we've gotten this far along with the house in the wrong location.
Thank you.
Terrence, Mike Terrence.
Thanks. I agree with a lot of Mr. Mehta's remarks. I'm really kind of struggling with this on many levels. I'm certainly sympathetic to the issue and the application and why it's here today. But where I'm really struggling is with the 4 findings for the variance, and, you know, whether an unnecessary hardship exists. Yes, I think this absolutely is an unnecessary hardship, right? But it's not a condition peculiar to the property. It doesn't necessarily meet the spirit and intent of the ordinance. Perhaps maybe if the infill standards did apply, I again agree with Chad. I'm not sure why they don't apply, but and these, you know, it certainly was an action taken by the applicant. So I'm kind of struggling. Yes, it seems negligible. As Chad mentioned, many of the houses along both sides of the street sit pretty close based on aerial imagery. So certainly would appreciate other comments board members have.
David?
I'm struggling. I have seen this problem many times over my career. I'm aware of this problem getting dealt with in the court process. It's not rare. I was trying to figure out as I looked at the packet what exactly was the error. And even though I think the surveyor's been gracious in labeling the error as a surveyor error, I don't really see great fault with the surveyor. What I do see is the builder designed a house on the setback line with no margin of error. That's risky in the real world because it's very hard to build with that level of precision. That's why these problems are not uncommon. And so the builder took a risk in not having any margin, 0.2 of a foot, a couple inches. Also, in my experience, it is prudent when you're close to the property line and doing foundations to have the surveyor out there to be sure you don't make a mistake. And the builder did not request the surveyor to be out there. The builder didn't have the surveyor do a survey after it was built, thereby creating another potential risk, which is the nightmare. And so the builder slash owner is asking us to bail them out. And I'm aware fortunately, it doesn't seem to be a drastic negative impact on the adjoining property, and that's certainly relevant. But I'm finding the builder, from my perspective, is responsible for this problem. So I'm struggling with finding 2 and 3.
Hey, Jessica.
Actually, I have a question for Attorney Kukuro. Sorry. As a board, are we able to vote to approve this variance if we also don't make findings that the applicant or the application has met all of the
all in our discretion.
Are yes, I guess.
It's all at our discretion.
Okay.
I mean, you would say the same, right? I mean, I know that was aimed at Krista.
So, Jessica, let me make sure I understand your question. Are you saying if the board doesn't find all of the standards, can it grant the variance?
Correct.
Let me just double check. I want to take a look at the language. I always want to do that when I am answering a question like this. Just a second.
That's actually why I'd argue that that's why there is a board of community citizens to make the decision, rather than, because if this was something that the city did administratively, it would have already been done or checked off. There would be a checklist. I think in my mind, there's some I don't even want to say leeway, or I think that the point. One part of this process is us taking a look at the realistic, like what is okay, what is, taking a look at this and saying, is this a common sense approach to, in my mind, that's how I've come to this. And I don't know, probably didn't.
Sure. I think so. What the language says is the board shall make the following findings, and it lists all 4. I think, Jacob, what you're speaking to in terms of sort of that discretion, or where the board is making its determination is, is the variance consistent with the spirit, purpose, and intent of the ordinance? And so I think that's really where the board is making its deliberation. So yes, I think to answer the question simply, Jessica, it is, the board does have to make all of those findings, and where it's sort of deliberating is, does this request, is it still consistent with the spirit and purpose of the ordinance, and kind of all of the other findings that are set out? Does that answer your question? I mean, that's a lawyer's answer, right? Which I know you can appreciate. So I think, if you all can come to an agreement, I think essentially that this variance is consistent with the spirit and purpose of the ordinance, that it's particular to the lot, that it wasn't caused by the applicant. Yeah, then you can grant the variance.
So I think you and I are saying the same thing, but I think Jacob is not saying the same thing.
Oh, I'm not.
Like, I think in order to vote yes, we have to make these findings, they all have to be yes. And if any of the findings are no, then we can't vote yes.
I don't believe that. I mean, I'm sure I can, in a black and white world, I can see that, but I mean, there's gray moments all the time. I mean, those are just my thoughts. So that's
please chime in.
Yeah.
I agree with Chairman Rogers. I think that there's mitigating circumstances and we do have to balance. Saying that, me, I live and die by these criteria, but I'm not sure that in every instance, every single one is applicable. And sometimes we have to apply our wisdom, to the best extent that we can.
Brian?
Well, I just want to add, this is a quasi-judicial board. And as a quasi-judicial board, you have to consider the facts as presented through the evidence and apply the facts to the Uniform Development Ordinance.
Yeah.
And you have to answer those 4 questions in the affirmative. Now, how you get to the affirmative, that's, I think, where you have your discretion. But this is a legally appealable decision. So you are going to be potentially reviewed and or scrutinized by a court, which is not quasi-judicial, but judicial. And so the quasi part is that you can bring in more evidence than you may not necessarily get to bring in a judicial proceeding. But you have to find facts and you have to apply those facts to the Uniform Development Ordinance. And the Uniform Development Ordinance is pretty straightforward. And when you're dealing with a variance, it's even more straightforward. Now, if it was a use permit, there's a little bit more wiggle room. But with a variance, you're saying that there's something irregular about the property itself that won't allow somebody to comply with the UDO. I don't know if the facts of this case fit into that. And so I think we're looking at what the remedy would be. And so that's a problem. In this case, the remedy is the problem, not whether or not, well, from what I hear, the remedy is the problem. And so I don't know if you necessarily have the latitude to not decide it based upon what the UDO says. So that's all I'll add at this point. But you guys are quasi-judicial, so you have to treat it like you would treat every other variance case.
And I'll also mention that there is no known opposition obviously not here. And even after being advertised, it's something to mention as well in a case like this. I think David.
I'm listening hard to the comments of my colleagues. I'd like to give Mr. Mitchell a chance. He raised his hand to say something before I offer another comment.
Thank you, Mr. Paletta. I just wanted to kind of, at least in my mind, this simplify kind of what we're looking at. I feel like there were two mistakes that were made. One, it was a surveyor's fault. There was a coordinate error in the AutoCAD program, and we take responsibility for it. And then two, as was mentioned earlier, the builder made a mistake as well and didn't order the foundation survey when he was supposed to, at which point we would have caught this earlier in the construction process. It wouldn't have all been framed. It wouldn't have been built. We could have at least a little bit more easily R&R the project. So in my mind, there's those two mistakes that are made. Where the house is it encroaches 1.5 feet into the front setback. In my mind, it's not a big deal because it's a small encroachment. And I mean, I've been out there myself, and I walked down to the house on the corner, and I look down, all the building faces, and more or less they all just kind of go back and forth, and they all kind of line up. It doesn't hurt anybody. It doesn't look bad or anything. But at the end of the day, there were two mistakes that were made, and I think, obviously, it's up to you to determine whether the variance can pass based on those mistakes. Thank you, Mr. Paletta.
Maybe you got more.
I am a stickler for detail. I'm not maybe more so than some of my fellow members. The property, I'm not sympathetic to the builder. I suspect he may have been wanting to just save a few bucks. Don't know, but that's why I see a lot of people don't incur that surveyor. If it was just the foundation, it'd be very simple. They got to fix the foundation, but the whole house is built. I've listened very carefully to Jacob's perspective. I won't call it argument, I'll call it perspective. And I really believe in it. We are created to try to give a little flexibility to this process to and so that and to do the right thing within the framework. We're not supposed to change any of the regulations, but I'm if I vote in favor, it would be because Jacob's perspective is powerful, and also Mr. Mitchell, at least for me, he took the right approach to be persuasive. He didn't try to, he took the right approach, and I find that persuasive.
Thanks, Dave. And I'll mention, we have no evidence to say that trying to save $1, I actually think it's unfair to make an allegation of something like that on our part when we have no evidence and no facts to support that. I think it's I think it's irresponsible to do that, because we have this mentality oftentimes of this us versus them, or the developer or builder being the bad guy. I just don't care for that. But I'll be voting yes on this. I think that this is a simple thing. I understand, actually, everybody that's made a comment about this, I completely understand that we want to check all those marks and say all of these have been met. And at the end of the day, it is the board's decision. It's not Krista's decision. And there have been times where both Krista and Brian have made recommendations to this board, and we do something that the opposite multiple times. And I'm not saying we do that often or should do that often. They're there to advise. And if it is appealed, it's their job to defend our decision. That's, this board nonetheless is the one who makes the decision. So I'll say that for what it's worth. Anybody else have any thoughts?
I'd like to say that finding number one is that unnecessary hardship would result from strict application of the ordinance. If we strictly applied the ordinance, this person would be required to tear that house down, or at least a portion of that house down. Personally, I feel that's unnecessary. The second finding, the hardship results from conditions that are peculiar to the property, such as location, size, topography. Hardships resulting from personal circumstances may not be the basis for granting a variance. Is this a personal circumstance? Yes, it is. The applicant's builder failed to follow the procedure. That's all I'll say about that. The third finding, the hardship did not result from actions taken by the applicant or the property owner. Well, we know that's not the case either. And as a matter of fact, the people who were responsible for building this house took those actions and failed to follow the rules, and that's why we are where we are. But that brings us down to the last finding. The requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. Okay, so we've got a building. It's closer than 20 feet to the street lot line. The house that was there before was closer than 20 feet to the lot line. It appears from cursory review that at least two of the other houses on the same block face appear, and if not those houses, certainly across the street, appear to be closer than 20 feet to the lot line. So from a character standpoint, I don't believe allowing this structure to remain and not tearing down the portion of the house that's in the setback. I don't think that's going to be a violation of the character of the area. I think that with respect to that allowing it to stay is consistent with the spirit and purpose of the infill standards that for whatever reason would normally apply in this urban tier residential neighborhood. And so I think it's the weight of the burden that would come from tearing out a piece of this house, and the recognition that having the house there inside the setback, while that's a violation, is still within the realm of reasonable with respect to what else is on that street, what else is on that site. So I feel like those two findings weigh more heavily for me than do the fact that the applicant did this, and this occurred through negligence. And so I am planning on supporting this variance application based on the facts as I understand them, and am happy to hear my colleagues who are brighter than I tell me why that's a bad approach.
All right. Anybody else?
Retchless here. I just have a question maybe to the city. What is there a fine that comes like with the accountability for this, and not a reward of granting, this be okay? I know it wasn't malicious, but what does inspections do?
So inspections wouldn't be the one to handle it. It'd be enforcement. Enforcement, like if it wasn't approved or wasn't or didn't come to the board at that time, depending on the time period, they would give a time period to correct it. If it wasn't corrected, then it would move to civil penalties until that correction was fixed, regardless of how it has to be fixed.
So there's no CO for this house right now, correct?
There shouldn't have been one, but I can't speak to what inspections has done at that point.
Yeah, and as Chad said, with our wisdom, I had the same thing happen to myself building a house back in the day, and I had more repercussions from the HOA than I did the county. And I can only hope that the builder really learns from this. And as Mr. Paletta stated, you just don't want to try to build a house on that close to your property lines. And but I'm for this. It's 17 inches. I don't think anything looks abnormally. It's fine in my book. I'd vote yes.
Brian, do you have something?
Yeah, I just wanted to add that so the Board of Adjustment doesn't necessarily have to give full relief to somebody who comes forward requesting a variance. That we are not the sole venue for solving the problems of every applicant. There are other options. There are options against the builder. There are options to, appeal an order that we would issue. There are enforcement issues. Is there going to be enforcement by the county because these folks are 1.5 feet over the property line? So everyone has their own venue that they operate within. The Board of Adjustment operates within the venue of enforcing the Unified Development Ordinance. And the express wording says that those 4 criteria have to be met in order for a variance to be granted by this board. So you can do what you want, but it's all about the integrity of the board itself. And if you have to twist it to make it work, then I believe that's a problem, because then you have to twist it for anybody who has suffered a harm, right? I have represented this board for 10 years, and I've heard many situations where people suffered unfortunate consequences. But life goes on. There's remedies to address that, but this board doesn't have to address everybody's failings. You just have to apply the standard in the UDO. That's what you have to do. And if you don't do that, then another case that comes along that may not be as sympathetic, that might be 3 or 4 feet over the line, it's not like there was a case not too long ago where the applicants relied on an approval by the city. And they had to come back and get a variance after they had followed all the steps and did everything that they were supposed to do. And then the city, turns out, made a mistake, but they still had to get a variance. This is a case where they didn't do what they were supposed to do. Should they also be able to get a variance? So, I'm here to advise the board. I don't want to step on anybody's toes, but in the practice of law, there's a saying that bad facts make bad law. And these are bad facts. And so people try and twist the law to fit these facts. And if you just let it play out, I just don't see there being any long-term terrible consequences. I don't think they'll have to tear down the house. Like you said, it's only 1.5 feet, so they shave 1.5 feet. I don't know. How much is that cost? I don't know. But it's not for this board to solve that problem.
But it is before us right now, Brian.
But it's before you on the evidence. It's before you on the evidence presented. And the evidence presented establishes that they don't, in my opinion, meet those 4 criteria. And the UDO says you shall apply the evidence and you have to meet all 4 of those criteria before you can issue a variance. That's what it says. That's what, you're there for. And yes, it's quasi-judicial, but because it's quasi-judicial, the applicant can appeal, and then a judge with a black robe can say, all right, I'm going to grant you the relief that you want because I think that they didn't properly apply this standard. But the problem is, if you twist it now, you're going to have to twist it for everybody else because that's constitution. That's due process.
You also know that not every case is the same.
But the law doesn't change. And the law in this case is the Unified Development Ordinance. And it hadn't changed just because somebody's story is different. So I'm just saying that because you're going to have more cases. And this is not going to be the last time that somebody's just a foot over. And there are alternatives to deal with that outside of the Board of Adjustment.
Then why didn't it go that way for this time?
Well,
I think of the Board of Adjustment as being the last
the
thing
Board
you
of
would come to.
the Board of Adjustment is far from being the last resort for an applicant. He's got a builder that didn't do what they were supposed to do that he can go against. If he has to make any alterations to his property, the builder made the mistake. Or he can appeal to Superior Court and say, they didn't give me the justice that I should have gotten at the Board of Adjustment. And he might get relief there. But the Board of Adjustment is far from being the venue of last resort.
Jessica, do you have something?
Yes, I just wanted to say that I certainly understand where Mr. Mitchell is coming from, and this is extraordinarily painful to have to vote no. But there was a reason why I asked the question about whether or not we could find that the answer to several of those questions was no and still vote yes. And that is that the UDO is the law, and we do have to make findings of yes, or we are supposed to make findings of yes in order to vote yes. And if we think about the last case, I had no problems with Attorney Thompson, you not testifying, but explaining to us the balloon versus the simulation. But again, it was a matter of, if we do this for him, then we really need to do it for everybody. And that's really not appropriate. And so it becomes a matter of, when do we apply this discretion and when do we not? And why are we applying the discretion? And then folks questioning, why are we applying discretion for this person and not that person? And so I think it gets kind of hairy there. But if we stick to the law, then we don't have that problem. And it is very painful to say no to Mr. Mitchell when it is just a foot or a few feet. But if we can't make the findings of yes for all of those, I'm not telling anybody else how to vote. Everybody's an independent member of this board, but I'm just explaining why I'm going to have to vote no, and also apologizing to Mr. Mitchell in advance, because it is very painful for me to say no. I wish I could say yes. And I just wanted to explain myself and my position.
Thank you. All right, any other board member? All right, again, variance, does anyone want to offer a motion?
I will,
I
Mr.
will.
Chair.
All right, Mr. Meadows.
I'm sorry.
Ms.
Go ahead.
Bouchane, you
No,
can do
sorry.
it.
Go ahead. Go ahead.
I heard Chad first, so
Okay, that's good.
All right. I
Okay,
hereby
who's
make a
the
motion.
second?
I'm
hold on.
sorry.
What?
I hereby make a motion that case number B22-00012, an application for a variance from the street yard requirements on property located at 1908 Southgate Street, has successfully met the applicable requirements of the Unified Development Ordinance and is hereby granted subject to the following conditions. 1, the improvements shall be substantially consistent with the plans and all information submitted to the board as part of the application.
We've got a motion for approval by Mr. Meadows. Is there a second?
I'll second. Bouchane.
Natalie Bouchane on the second. Amanda, will you call everybody?
All right. Meadows,
No.
Pauletta,
No.
Rogers,
Yes.
Retchless,
Yes.
Major,
No.
Tarrant,
No.
Bouchane.
Yes.
All right, let me do this.
Motion fails 3-4.
Yeah.
All right. We have to inform you that your request for variance hasn't been approved today by a vote of 3-4. All right. We are at, going along here. Do we want to call the next case?
Okay. B22000013 City. A request for a variance from the sidewalk and pedestrian passage requirements. The subject site is located at 400 West Main Street, is zoned downtown design core DD-C and in the downtown tier. This case has been advertised for the required period of time and notarized affidavits verifying the sign postings and letter mailings are on file. Seating for this case is Meadows, Pauletta, Rogers, Retchless, Major, Tarrant, and Bouchane.
All right. Well, let's go ahead and get everybody on camera. We'll
Chair Rogers, I believe.
I think Mr. Terrence recused himself, Chair Rogers.
That's about. Okay, so earlier this meeting, I asked this question, but I want to ask you again. So with Mike Tarrant recusing himself, that leaves us with 6 members, not a full board of 7. Do you want to continue today with the hearing, or you also have the choice of continuing the case until a time when we can all 7 of us can hear the case?
Yeah, Phil, you can weigh in too, but I think we'd like to continue with 6 members today.
Okay, got it. All right. We need to do the oath. So anybody who plans on giving testimony, we'll need you to raise your right hand. Do you swear or affirm the testimony you'll give today is the truth and nothing but the truth? Philip Oliver?
I do.
Crystal Ross?
I do.
Alden West?
I do.
And do you consent to this remote meeting platform? Alden?
I do.
Crystal?
I do.
Philip?
I do.
All right, and I think that is everybody, yeah. Cole, we'll turn it over to you.
Good afternoon. I'm Coordinator representing the Planning Department again. Planning staff requests the staff report and all materials submitted at the public hearing to be made part of the public record with any necessary corrections as noted.
So noted, thank you.
B22000013 is a request from a variance from the sidewalk and pedestrian passage requirements. The applicant is Alden West. The case area is highlighted in red. The site is in the downtown tier, zoned downtown design core, DDC, and is in the city of Durham's jurisdiction. The existing use is a commercial office building. Alden West applicant requests a variance from the sidewalk and pedestrian passage requirements. The property is located in the downtown design district core zoning design district, and in the downtown development tier. The applicant requests a variance from the Unified Development Ordinance, section 12.4.2, which requires sidewalk from building face to back of curb. The applicant is proposing that instead a full sidewalk on the corner of West Morgan Street and Morris Street. 2 planting areas with the cast on seat wall will be included to reduce the width of sidewalk provided. 1 planting area will be 43 linear feet and the other 33 linear feet, with the combined area of 478 square feet. That proposes a similar designed area at the intersection of West Main Street, Morris Street, and East Chapel Hill Street. The area is 132 linear feet and has an area of 718 square feet. The applicant is also requesting a variance from UDO section 16.2.2A1, which requires 1 pedestrian passage per 250 square feet of aggregate building facade per development along a street frontage. The applicant proposes only having 1 pedestrian passage along the west side of the project, running south to north, with no second patch running east to west. Chad, you have a question?
Thank you. I do. I don't recall ever prior to today having a variance case to the pedestrian passage provision. Is that accurate? Did I miss it? Have we ever heard in the last 4 or 5 years, has there been a variance on pedestrian passage to your knowledge?
There is not.
Okay, thank you.
You're welcome.
All right, any other questions for Cole before we hear from the applicant? All right. I'm not sure who I'm not sure who we should turn it over to on the applicant side. I know there are 3 here.
Chair Rogers, this is Phil Oliver with LS3P. I'm the chief lead designer and project manager for the job for LS3P Associates.
We'll turn it over to you.
Well, I appreciate it. Thank you. Alden, I believe there's a presentation we've put together, correct? I just want to do a quick preamble about the site, give everyone sort of background on it, and then Alden is going to take over and talk through the various variance requests. I do want to start off, say thank you all for your time this afternoon. I sat into the last variance request, and I do want to commend you for sort of a vigorous debate and exceptionally thoughtful approach to the work that you're doing, and that does not fall lightly on us. We feel like we have a couple of requests that we think are detrimental to the project, and so we do want to walk through them with you. Cole, if you don't mind, could we call up the presentation? I don't know which page it's on.
Yeah, absolutely. Hold on 1 second. I'm gonna go ahead and stop sharing, and I'll share your presentation.
I think if we just go to, let's see, which page is it? Let's start with the site plan. I think it's okay.
Site plan is on page 8. Oh, sorry. But this one is on page 3.
Just tell me this one.
Mm-hmm.
Oh, well, sorry, it skipped.
That will work. Yep. Thank you
Okay.
so much. I appreciate it.
You're welcome.
So the Novus is the name of this project. It is replacing an existing office tower that has been demolished. It represents 670,000 square feet of mixed use. It's a 27-story tower, combination of retail on the ground level and 242 residential units, a mixture between apartment and condominiums at the top level. The podium itself is essentially the footprint you see before you, which it represents, like I said, retail and ground floor, mid-block entry into the residential elevators that take you up. There's access to a below-grade deck, 1 level below grade from Great Jones on the north side of the upper left-hand corner. And then the lower left-hand corner is access to the upper level. There are 5 floors of parking for 380 spaces of parking podium. The intent there is then that the parking podium is actually wrapped on 2 sides with residential units in order to sort of screen the bulk of the parking deck from the exterior as much as possible. So that's in essence, the sort of, this is all one parcel, the triangular site as a whole. There's a phase one, as you see, and then phase two would be the other half of the parcel, which will remain at grade, but developer owner would like to pursue that phase two while this phase one is currently under construction. We have gone in front of the HPC for both the demolition of the existing building, and we have approval for the new COA to proceed with current design. But Alden, I'll go ahead and turn that over to you now if you want to go through that piece. Are there any, we can do questions, Chairman Rogers, along the way?
Yeah, we'll finish your presentation and we'll do questions.
Okay. All right. Thank you.
Okay, great. Yeah, thanks, Phil. And my name's Alden West. I'm a civil engineer with Stewart, and I'm representing the developer and applicant on this case. Cole, can you go to page 2? And I guess I could mention also, I'm a resident of Durham, live on American Drive. And so we're requesting 2 variances here. I'll go over our request for the pedestrian passage variance, and then my colleague Crystal Ross will go over the sidewalk variance request. And so for the pedestrian passage in the UDO section shown there, requires one passage every 250 feet of aggregate building facade per development along a street frontage. And Cole, can you go 2 slides forward? Thank you. And so the building here, as Phil mentioned, is phase 1 of a 2-phase project, with phase 2 coming at a later date over on the west side. And what we're requesting here is a variance for the passage that would run just east-west from Morris Street. So Morris Street runs along the east side of the site there, with Great Jones Street along the north, and Main Street and Chapel Hill Street to the south. And so I'd just like to draw your attention to the sort of triangular geometry of the site, which is unusual. And the strict application of the ordinance would require a passage at each of the 3 frontages. And so again, we're only requesting a variance to the east-west passage along Morris Street, and would be required to and plan to construct a passage that runs north-south between Main Street and North Great Jones Street. Can you go to the next slide, please, Will? Yep. So this exhibit just shows some of the existing pedestrian passages downtown. It's just kind of a sample of some of them. And as you can see, the ones shown here, they're all rectangular in nature. They all connect between 2 points. So whether in these 3 cases, it's a parking lot to a street or an alley. And then on the bottom right, you can see there's an exhibit there that's from the UDO, and it's sort of the only example, shown in the UDO. And it is a rectangular connection that's being shown. So next slide, please. And this exhibit just shows the lengths of each of the frontages and the potential locations of the pedestrian passages. So you can see the east-west passage there that we're requesting a variance to from the Morris Street front, or through the Morris Street frontage, which is the shortest frontage of the 3 on this project. And then next slide. And so the intent of the ordinance as it was written in the staff report, and I think is fairly obvious, is to promote walkability and connectivity downtown. And so this exhibit just sort of helps kind of put numbers to that connectivity and sort of evaluate the connectivity through the site as it relates to these passages and to the UDO requirement. And so what we're showing here are two, or one probably most likely walking path through the site for pedestrians. And so you can see that there's a starting position along Main Street and an ending position at the intersection of Great Jones and Morris. And so there's two paths shown here. One in red is shown if a pedestrian is using only the north-south pedestrian passage connection, and you walk between Main Street, Great Jones Street, take a right to head over to the intersection and crosswalks at Morris and Great Jones. And then the other alternative path, if there were an east-west pedestrian passage, is if you head north, starting in the north-south pedestrian passage, and then you turn right into the east-west passage, and then head north again on Morris. And as you can see down on the bottom right, the distances shown, the walking distance is actually slightly longer if you make use of that east-west passage. And so, we're just showing two kind of common, most likely scenarios for starting and ending points, but you can move those around and you pretty much end up with the same result, which is that the east-west passage is not helpful in terms of walking distance connectivity. And one of the main reasons for that is because the passage is not really connecting between 2 points like what we saw with the earlier exhibits, where you're connecting parking, to a street or an alley. Here, you're connecting essentially to another passage at one point on the left side there, or the west side of the east-west passage. And on the east side, it lets out on Morris Street mid-block where there's no crosswalks, and you're ending up having to go either north or south to get to a crosswalk, really to get anywhere. And this all kind of goes back to the triangular shape of the site that's sort of driving, this requirement to have two passages for 3 frontages, which is not really something that the ordinance covers. And again, the ordinance seems to be thought through more in terms of a rectangular block connection instead of this sort of triangular kind of odd configuration. And so, again, it just leads to a sort of unnecessary east-west passage connection that's not improving, walkability, walking distance, and connectivity, and could cause confusion among pedestrians as they're in that north-south passage. Do I go down the east-west passage? Do I go straight? And there's not really a use for it. And we believe sort of goes against the intent of the ordinance, which is to improve connectivity. So if you could please go to the next slide. Yeah, and so this slide shows, just with the north-south passage, how it is actually very beneficial here to have a north-south passage. Your walking distances there using the passage 251 feet compared to if you had to walk all the way around the building, you're at 422 feet. And again, you can kind of play around with the starting and ending positions, but there's clearly a benefit to having the north-south passage. And it sort of creates a stark juxtaposition, I think, to the east-west passage. Yeah, and again, the north-south passage, it directs pedestrians onto Main Street at a more appropriate location where they can access pedestrian crosswalks, public spaces, retail, and would be a better overall design to just have that passage. Can you please go to the next slide? And so this exhibit shows sort of a theoretical east-west passage if the ordinance were interpreted to require the passage across the length of the site, which again, the ordinance doesn't really cover this scenario. And what it's showing with the distances is that, along Morris Street, it's 322 feet of frontage, and the requirement is 200 every, if you're over 250 feet, you need a pedestrian passage. However, because of the triangular nature of the site, it tapers down towards the west to, once you reach the north-south passage, you're actually less than 250 feet. You're at 235 feet roughly, which is less than, less than the 250 feet that the ordinance would require, a pedestrian passage along a frontage. And then as you continue west, obviously it tapers down to 0. And so, what this shows is that the east-west passage is limiting the usable space on site. It's a 12-foot wide passage that's required, which is not insignificant. Also considering, the meeting other UDO requirements in the building, such as bike parking and providing, ancillary pedestrian and service corridors. And so, yeah, that's the point there is that it's restricting and limiting from a site design standpoint, the available space on the site that can be developed, which is resulting from the triangular shape of the site. And so what we're proposing in lieu of the passages is pulling the corners back at each side of Main Street, creating plazas, which are, creating nice publicly accessible and amenity spaces, which is in line with the comprehensive plan and the objectives of the UDO. And it providing these plazas better integrates the project with downtown, and especially at this critical intersection of 5 Points, which is right there on the South Plaza. And so, just to go over quickly the general findings, and unnecessary hardship would result from the strict application of the ordinance. It shall not be necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. And so, what we're intending to show here is that the east-west passage is unnecessary because it does not provide a benefit to pedestrian circulation, and actually create some confusion and inefficiency in terms of the pedestrian circulation. And then it produces a hardship by cutting through the site's smallest dimension, which is the north-south dimension, which is already limited by the site's geometry and tapers down to the west. And again, forces an inefficient pedestrian circulation and inhibits the developer's ability to create a logical circulation pattern around and through their site. Finding 2, the hardship results from conditions that are peculiar to the property. And so I think it's clear that the hardship's a result of the triangular geometry of the site, which is atypical from a standard block for which pedestrian passages are intended. The hardship did not result from actions taken by the applicant or the property owner. And again, it gets back to the triangular geometry of the site. And then the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. And so, our understanding of the purpose and intent of the ordinance is to promote walkability, connectivity downtown, and removing the east-west passage should better serve that intent and spirit of the ordinance, and as well connect by pulling back the building along Morris Street on each end, creating plaza areas. It reduces the frontage along Morris Street, as well as creates nice public amenity areas, which are in line with both the ordinance and the comprehensive plan. And so that concludes this portion of the presentation, and I'll turn it over to Crystal to discuss our variance request on the sidewalk ordinance provision. Thank you.
Thanks, Alden. As you mentioned, I'm Crystal Ross. I'm a landscape architect with Stewart. I'll be going over the second variance request, which is from the UDO section 16.4.2, which requires sidewalk from the building face to the back of curb for the downtown district. So as you can see, the application of the UDO can be met, but however, this unnecessarily results in quite a bit or a large amount of impervious surface due to the geometry of the site, as Alden has mentioned, with the 3 sides that abut streets and the 2 larger intersections. This results in some instances where there is up to 65 feet between the building face and the back of curb. The application also would cause some grade slope issues, resulting in slopes that exceed ADA accessibility for plaza spaces in both the north and the south. On the right, we have what we have proposed, which for the variance, we are asking for the addition of plant areas, cast in stone seat walls, and stairs between the building face and the back of curb. This variance will help to reduce that large amount of impervious area and also result in less stormwater management, which would help the city in their goals for the conservation and environmental goals set forth in the comprehensive plan. Next slide, please. This just kind of zooms in on both of those 2 plazas where we are asking for the variance. The first plaza on the north, at the intersection of Great Jones Street and Morris Street, we have 2 planting areas there with the cast stone seat walls that you can see around the edges there. One of them having 43 linear feet, the other with 33 linear feet. The combined planting area is 478 square feet. And I mentioned this because, as we mentioned before, we're trying to decrease the amount of impervious surface there. This will also, the grades will require 15-foot wide stairs that you can see there on the corner, northwest corner of the plaza there. And this will provide pedestrian access from the Great Jones Road down to the finished floor of the building there. And then on the south side, we have a very similar approach at the intersection of Morris Street and West Main Street. There's only 1 planting area in this plaza, and we have about 150 linear feet of stone walls. We also do have a proposed monumental stair there. That's about 30 feet in length. And the total square footage there for the plant area is about 718 feet. The proposed seat walls that you see and the stairs in the plant area help us to kind of define the usable space and orchestrating a safe pedestrian path of travel, which kind of helps us to mitigate some of those topographic challenges and assist in kind of the micromanagement of the stormwater here at these two plazas. The proposal reduces the impervious surface by 1,195 square feet and provides the opportunity for us to do enhanced plannings that will promote pedestrian health, clean air, reduce heat island effect, et cetera. That again goes to meeting some of those goals set forth in the comprehensive plan. You can go to the next slide, please.
Yeah, I don't know.
We kind of dive in here on the next two slides, looking at the grades. This is the existing grades, and I just wanted to note, if you look at the northern plaza, the cross slope here is well over the allowable 2% maximum slope set by ADA. We have about 2.5 in the north plaza, and then down on the south plaza, it's 3.5. The grades, this is the proposed situation, and these will obviously assist in kind of, once again, defining those usable spaces, but also providing a safe and accessible route for pedestrians to get in and out and around the public realm. And if you can go to the next slide. The last kind of case that we're making for the variance is that in addition to providing reduced impervious impact and a safe and accessible route, we also will be providing context compatibility with surrounding plaza areas. So if you look at the plaza on the north, Great Jones and Morris Street again, several of those adjacent corners also do not meet the UDO, which requires sidewalk from face of building to the back of the curb. You can go to the next slide, please. Additionally, with the south, there are the same thing. There are plazas that do not meet the UDO, and what we're proposing for this south plaza will really help to kind of create this nice welcoming space for the downtown district and kind of create a vibrant, store frontage and make sure that the retail space there in our new proposed building is, successful and brings in revenue to the city of Durham. I believe that's the end. So I just wanted to say, for these reasons, installation of the sidewalk between building and the back of curb is clearly unnecessary, as it would not improve the pedestrian connectivity in the downtown district and will increase stormwater runoff. The requested variance successfully improves the public open space in the downtown district and is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. That's all that I had. Phil or Alden, did you want to add anything else on the end of that?
I think we're okay. Go ahead and.
All right. Are you guys? Are you done? Is that all you?
I believe, yeah. I think that concludes sort of the presentation, sort of our intent, and so what we want to put in front of the board today.
Or let's take some questions. I see Chad Meadows has his hand up.
Thank you, Mr. Chair, and thanks for the presentation. You guys do beautiful work. It's always easy to see what you're proposing. That said, I did have a couple of questions, just so that I'm 100% clear. The pedestrian variance request 1 is the pedestrian passage variance request, and as I understand it, this application seeks to install a pedestrian passage on what is, I think, the western side of the building, stretching from the north to the south. But the requested variance is to not include an east-west connection through the building. Am I understanding that correctly?
Yes, that's correct. And I'll point out that the north-south passage, with the construction of this building, the north-south passage would be constructed as part of phase 2 and would become required and necessary as part of phase 2. And so as part of this application, there's no north-south passage proposed. It's going to be open space in that area until phase 2 is built.
Okay. And so the next question that sprung to mind during your presentation was obviously that would not phase 2 also require some kind of pedestrian passage requirement? And I guess then the thinking is that this north-south passage will serve us as the single pedestrian passageway. And the interpretation is that that through the development of phase 2, the configuration of the remaining lot is such that there's not enough building frontage to trigger the requirement for the east-west pedestrian passage. Is that, am I thinking about that correctly?
Yeah, that's correct. We discussed this with planning. And so there's not a clear way, it's not clearly laid out in the UDO how to address this situation. Mm-hmm. And so in discussions with planning, their thought was to have sort of a Y shape or a T shape through the site.
Mm-hmm.
And that's what we were showing on one of our earlier exhibits. And yeah, to your point earlier, our intent is to provide just the north-south pedestrian passage at full build out of this property.
Right. So not necessarily a Y shape or a T shape, that the passageway would be north-south, more like a small case I than a Y or a T. Okay.
Yes.
Yes, sir.
All right. And so what is the hardship with respect to turning our lowercase I into a Y or a T?
Yeah, so our hardship is that the site is triangular, and so it's tapering down and becoming smaller and smaller in the north-south dimension the further west you go. Mm-hmm. And so obviously we're just over the requirement to have a passage at Morris Street, but then as you head west, the site is constricting and tapering down. And so, obviously to the point where you get towards the end of the property, essentially the north-south dimension is 0. And that would make that portion of the site completely undevelopable. But it's creating a hardship, even in the center of the site at the location where the passage, the east-west passage meets the north-south passage. Again, that north-south dimension is less than 250 at that point. And so just cutting through the site at that small of a dimension is creating a hardship in allowing us to have, usable space, along on the north and south sides of the site.
Okay. One more question, and then I'll yield to my colleagues. Would you please tell us a little bit more about so now I'm on the second variance, the sidewalk variance, and there are a couple of planted areas that are being proposed as an alternative to sidewalk. What is from the looks of the drawings, and I know this probably wasn't the intention, but when I looked at the drawings, it looked like they were grass. Is that what you're anticipating, or would there be something other than lawn inside of these planted areas?
There will be shrubs and plants. Yep. It will not be lawn.
Will not be lawn. It will be shrubs and maybe ground cover or something like that.
Sure. Yep. Perennials, shrubs, ground cover. Yep.
Okay. Thank you.
You're welcome.
All right. Any more questions for the applicant? Or any of Cole, would you mind stop sharing for a minute? I want to see everybody. Any other questions? Just take a quick look around. All right. Is there anyone here Anyone else wanting to speak in favor of this application for variance? Request for a variance, I should say. Anyone here to speak in opposition? All right, not seeing none. Another chance for questions, or we can move into deliberations. Anyone have any thoughts? All right. Does anyone want to offer a motion?
Mr. Chair, Retchless here, I'll offer a motion.
Okay.
I hereby make a motion that case number B22000013, a request for a variance from sidewalk and pedestrian passage requirements on property located at 400 West Main Street has successfully met the applicable requirements of the Unified Development Ordinance and is hereby granted subject to the following conditions: that the improvement shall be substantially consistent with the plans and all information submitted to the board as part of the application.
All right, we have a motion for approval by Mr. Retchless. Is there a second?
O'Shane, second.
Natalie Beauchesne on the second. Amanda, I'll take it away.
All right. Meadows,
Yes.
Pauletta,
Yes.
Rogers,
Yes.
Retchless,
Yes.
Major,
Yes.
and Bouchane.
Yes.
Motion passes 6-0.
All right, by a vote of 6-0, your request for a variance has been approved. Appreciate you guys sitting through the long meeting today. One of the longest ones we've had in quite a long time. All
Thank
right.
you all.
Have a good day.
Appreciate it so much. Thank you.
Moving along here. On the agenda, we have no old business. We have no new business.
Chair Rogers, this is Jessica Dockery. May I take just a moment of the board's time to introduce a new Board of Adjustment staff member?
That's right. Yes, please.
So with us, we have Leah Larkins, who is going to kind of fill in for Eliza, who left us sadly back in the fall. So Cole will move out of the primary into the helper role, and Leah will, once we get her trained, be the lead, and she'll be our contact going forward. Leah, you want to say anything? Say hi.
Sure. Hi, everyone. Thank you so much for welcoming me in. I've been with the city of Durham for a little over a year. I'm from North Carolina, Wilmington native, and I'm happy to be back after traveling around the country, working for different planning departments following my husband, who was an active duty Marine at the time. So happy to be home and happy to be here to help with these cases. Thank you so much.
Well, looking forward to having you here. Thank you for joining us today. I know this has been quite a day. So looking forward to working with you, yes. All right, let's move into the approval of orders. There's several in here that we won't be voting on today, including, well, a few of them. But the first one hey, Brian.
Hey, we still under new business?
Well, there was nothing under new business, but yeah.
Okay, I just wanted to remind the board about next month's meeting. We've got an appeal. And I don't believe anyone on the board has been there for an appeal. And were you there for the monopole appeal, Jacob?
Maybe not then. Okay.
I think that was the last appeal, I think.
Okay.
But so I just want everyone to make sure that they read their packets, because it's different than anything you've ever seen before. I'm just telling you ahead of time, right? And if you were struggling with the UDO and applying the variance standards, it's going to be a lot different next month, because you're going to have to apply standards that you're not even familiar with. So when you get the packet, read through the packet, read through the narratives that the appellant and the I don't even know what we got, an appellant and a other party, I guess, the permit holder, I guess, have submitted. You know, they're two big land use firms, lots of words, lots of legal jargon. So I want you to be aware of what we're getting into, right? It's going to take us all day to deal with it. So,
and that's going to be in person. So next month
it's going to be in person. So it's going to be a little circus-like, right? Because you're going to have at least 20, 30, maybe more people in opposition. They're all going to want to speak. You've got legal arguments that are, you know, even for people who have practiced in land use for a long time, they're legal arguments that are a little bit difficult to grasp, and they're just going to drop it in your lap. So just read your materials, ask questions. It may even help to do a short question and answer with me ahead of time if you want to.
I was going to say, should we do a closed session?
I don't know if we can do a closed session because there's no pending legal matter. And even though you could do the closed session to preserve the attorney-client privilege, there's no privilege really to, you know, to protect. But you can ask me questions, and I'll certainly answer those questions. We just have to do it in open session. But just get ready. I don't want anybody to be shocked when they get the packet. So that's new business.
Thanks.
Mr. Wardell, Chair Rogers has also requested that we hear the Green Flea Market on that same day. So we would get both of our appeals out of the way that we needed to meet in person for. So if everyone would please plan to be here till 3 at the earliest.
Is that
it's a notice of violation appeal.
Is that with Attorney Perry?
Yes.
I wouldn't suggest that.
Why?
I wouldn't suggest doing both those in the same day.
Why?
I
mean, we've been here. It's almost what, 3 o'clock now.
I'm telling you, don't do those in the same day.
Okay.
Because
take his word for it.
Who's ready for it?
There will be a lot of discussion. It will go on for a long time.
Okay. All right. Look.
So I can take it off. I agree that we will probably spend at least 5 hours on West Point. So
I would split those two appeals up. You know, do one next week, next month, and then if you wanted to do anything else, I would bring back that monopole case. That's going to take 15 minutes.
Yeah.
Right. Ask the applicant if they would consent to come back early. Do that, knock that out. But I would not do that flea market case and West Point in the same day.
All right, well, then let's move the flea market to June then.
They will only do it if they do it and meet in person. And we do not have permission to go back to in person with the exception of this one case.
Really?
What?
Oh, that's hilarious. Okay.
Say that again.
The city council has not given us permission to go back into continued in-person meetings. We got special dispensation basically for the West Point case.
Okay, they'll let you do it in June. They'll let you do it. Just go to them and tell them we got an appeal. We need to do it in person. They'll let you do it.
All right, let's move forward. I mean, it's been a long meeting. We can.
They'll let you do it, but I just would not do the two of them in the same day, because you're not going to get good results.
All right, well then let's push the flea market off then. Chad, you had your hand up first.
I did, thank you. I would like for the agenda to reflect some time with Mr. Wardell or Ms. Kukuro or whomever, so that we don't skip over that or that doesn't get lost in the shuffle for our next meeting. It's very important to me that we have an opportunity to ask questions before we get into this. And I very much want the agenda to reflect that we intend to take a little bit of time to do that, if that is acceptable to everyone, and there's no procedural problem with that.
I don't have a problem with that. David, you got something?
I want to share, I participated in numerous contested Board of Adjustment meetings. And it is critical that the chair control the meeting. Lawyers are aggressive by whatever. And I think today one of the lawyers should have been reined in a little bit. Jacob, we need to run a tight meeting. And there needs to be a time when there's no further comment from the attorney. The way we handle
I've done this. I've chaired a very contested case that took us 5 hours, and so I'm prepared.
Good, and I support you, but when we deliberate,
nothing more.
I don't want attorneys questioning us and interrupting us.
Agreed.
Thanks.
Completely agree. Mike?
I just wanted a clarification of where that meeting is next month.
City Council Chambers.
City Council Chambers, thank you.
It'll be in the packet, of course, or in the meeting information that they'll send out as well. Sweet dog. All right, let's keep on moving forward. I think we've got approval of orders here. Krista put something in the chat about order 55, which is the first one. Paletta, Meadows, Retchless, and Beauchene voted no on this. That means
one of them has to make the motion, one of them has to second, and 4 of them, since Kip isn't here, have to vote to approve the order.
Okay. So who wants to make the motion for B21000055?
I'll use the last brain cell remaining to make the motion.
No shit. Yes. All right. So we got a first by Mr. Meadows. Is there a second?
I'll second Beauchene.
And Beauchene on the second. Amanda, we'll let you take it over. Krista, do you want to clarify who can vote? Or does everybody vote?
I'm sure Amanda's got it, but you'll just call those folks who are listed there.
Those 4 names. Yeah, got it.
Okay, just call the 4 that was.
You can call Kip too.
Okay. All right. Kip?
Okay.
Absent.
Yes.
Meadows? Pauletta?
Yes.
Rogers?
I'm not on that list.
Oh, yeah.
Amanda, it's in the chat if you don't see it.
Okay, I see it. Okay. I'll redo this. Okay. Kip here. Pauletta?
Yes.
Meadows?
Yes.
Retchless?
Yes.
Beauchene?
Yes.
Motion passes 4-0.
All right. Thank you for that. Next one is B22000003. Need a motion and a second for each of these guys. Who wants to take it?
Retchless.
Retchless on the first. Who's second?
I'll second Beauchene.
Was there any limit to who can vote on this? Like this case wasn't from today, so I don't remember.
Right.
Yeah, and I don't think I was sat on any of them last month, so maybe I can't vote. Sorry.
I have Terry, she's so detailed. She gave me a list of people who can vote for this case.
Can you-
And Boucher, I don't see your name highlighted.
Yeah.
Okay, all right. Well, then
We
take
need
my
somebody
second
else on
away
the
then.
second there.
Yes.
Amanda, you want to clarify who can vote on that one real quick?
Okay, I have Kip, Meadows, Pauletta, Rogers, Ratchless, Major, and Tarrant.
Okay.
All right, I'll second Meadows.
Meadows on the second.
Okay. All right. Kip, Meadows,
Yes.
Pauletta,
Yes.
Rogers,
Yes.
Ratchless,
Yes.
Major,
Yes.
Tarrant.
Yes.
Motion passes 6-0.
All right, we're not going to vote on 7. I'm assuming that's because there was opposition. The next one is going to be, and Mike, Retchless, you won't be able to vote on this one. You recused yourself, but B2200009. There'll be 6 of us who did this one.
Mhm.
Who wants to make the motion?
Bo Shane, I'll make the motion.
Thank you, Natalie. On the second,
Terrence, second.
Terrence on the second.
All right. Meadows,
Yes.
Pauletta,
Yes.
Rogers,
Yes.
right? Major,
Yes.
Tarrant,
Yes.
Boucher.
Yes.
Motion passes 6-0.
All right, our next one is going to be B2200010. This is a unanimous by all 7 of us. Who wants to take it?
Meadows, move approval.
All right, Mr. Meadows.
Bo Shane, second.
Bo Shane on the second.
All right. Meadows,
Yes.
Pauletta,
Yes.
Rogers,
Yes.
Ratchless,
Yes.
Major,
Yes.
Tarrant,
Yes.
Boucher.
Yes.
Motion passes 7-0.
All right, next one is B2200013. Mike, Tarrant can't vote on this. Will be the remaining 6 of us. Who wants to take it?
Bo Shane, make a motion.
Bo Shane on the first. Who wants second? Or who wants? Meadows on the second.
All right. Meadows,
Yes.
Pauletta,
Yes.
Rogers,
Yes.
Ratchless,
Yes.
Major,
Yes.
Boucher.
Yes.
Motion passes 6-0.
All right, guys. I think that is all we have. Just remember, in person, May 24th, 8:30, City Council Chambers. I'll be there at 8, but I would suggest that you get there a few minutes early as well. It's been a while. I think there are several members of this board now who haven't been, you haven't even met in person on this board. So it's going to be different, and a lot of people. It's nice to get in there, get your bearings, get set up. We probably won't have paper applications, so if you want to bring a laptop, I always brought mine. You can do that and set it up, and or you can have your documents on there if you would like. And until then, we'll see everybody then.
Right.
See y'all.
Have a good day.